Good morning, everyone. This is the Joint Standing Committee on the Judiciary, and we have a half day of hearings today. We're going to try to wrap up by around 12:30. I posted the order of public hearings in the chat for committee members and members of the public who want to see kind of how we'll progress today. And let's see, we will start with our usual round of committee introductions. This is the Joint Standing Committee on the Judiciary. We'll start with our usual round of introductions, and Senator Sanborn, we'll start with you this morning.
Thank you, Senator Carney. It's nice to be with you folks today, the only day that my other committee is not also meeting each week. My name is Heather Sanborn, and I represent Senate District 28, which is half of Portland and half of Westbrook.
Thank you. Senator Keim?
Good morning, everyone. My name is Lisa Keim, and I proudly represent Senate District 18, which is northern Oxford County and two communities in Androscoggin.
Thank you. And Representative Harnett?
Good morning, Madam Chair. My name is Tom Harnett. I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I live. Nice to see everyone.
Thank you. Representative Babbage?
Thank you, Madam Chair. Good morning, everyone. My name is Christopher Babbage. I represent House District 8, which is 82% of the voters of Kennebunk.
Thank you. Representative Reckett?
Good morning. My name is Lois Reckett, and I represent District 31, which is the ocean end of South Portland.
Thanks. Representative Moriarty?
Good morning, all. I'm Steve Moriarty from House District 45, which is my hometown of Cumberland and part of Gray.
Thank you. And Representative Sheehan?
Madam Chair, and good morning, everyone. My name's Erin Sheehan, and I represent Biddeford's very sunny today, House District 12.
Thank you. And the people are jumping all over the screen. Let's see. Representative Thorne, I believe you are next.
Thank you, Madam Chair. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and a portion of Etna, up in also sunny and hummingbird infested Penobscot County.
Thank you. And Representative Evangelos?
Hi, everyone. Welcome, everyone. It's Jeffrey Evangelos, House District 91. Thanks.
All right. And let's see, I should introduce myself. I'm Ann Carney. I represent State Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And as a note to members of the committee, as well as members of the public who will be watching or listening or participating, public hearings are really our time to hear from the public on the legislative measures that our committee will consider. We will start with sponsors introducing bills. Sponsors have unlimited time. Members of the public who speak before the committee are asked to maintain a 3-minute time limit, and we'll keep track of that for you. You will be asked questions potentially by committee members after that time frame. And we usually do we always do the proponents and then the opponents, and then neither for nor against. And we'll follow that same pattern today. And with that, we have our first bill today, which is LD 1480, and that is an act regarding the review of law enforcement use of deadly force. That will be presented by our fellow committee member, Representative Sheehan. And then we will hear from Emma Bond from the ACLU Maine, who will provide additional information on the bill. And so with that, Representative Sheehan, welcome, and you can begin your presentation whenever you're ready.
Thanks, Madam Chair. Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Erin Sheehan. The sponsor, Representative Talbot Ross, regrets that she can't attend today's public hearing. due to a death in her family. So I am here to present LD 1480, an act regarding the review of law enforcement use of deadly force. Emma Bond, the legal director for the ACLU of Maine, is here to speak to the details of LD 1480 and to the work that's gone into its drafting. Representative Talbot Ross wants to thank her in particular, as well as the Attorney General, for his attention to and collaboration on this proposal. She is deeply grateful as well to the chairs for accommodating her unexpected absence and to me for stepping in to introduce the bill. Representative Talbot Ross looks forward to joining us for the work session, and everyone should feel welcome to contact her in the meantime with any questions or requests for information. And with that, we will hear from Emma Bond.
Thank you very much, Representative Sheehan. And because we always ask this, are there any questions for Representative Sheehan about the introduction of the bill? I am not seeing any. And so at this point, I will bring in Ms. Bond if I am empowered to do that. And Ms. Panett, could you please bring in Emma Bond from the attendee space and then also give me a co-hosting authority? Oh, great. Thank you. And Representative Harnett, are you going to be doing the timing? Is that the reason for your raised hand?
Well, I have a question, and yes, it is the reason. That's one of the reasons for my hand, which I would keep up. And it has to do with timing. As Ms. Bond is in essence presenting the bill for the sponsor, am I correct to assume that she is not limited to the 3 minutes in explaining the bill?
Yeah, I think under the kind of urgent circumstances of Representative Talbot Ross having had to depart for a death in the family, that would be appropriate. Is there any objection by committee members to letting Ms. Bond have more than 3 minutes? Thank you all for
Thank you. And I will keep my hand up though for the future people testifying.
Thank you. And with that, we'll welcome Emma Bond. And Ms. Bond, thank you for joining us. You can proceed.
Thank you very much. Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. Hello, good morning. I am Emma Bond, the legal director of the ACLU of Maine, and I am presenting today in support of LD 1480. Before getting into the nitty-gritty of the bill, I wanted to start by zooming out and talking about the serious problem of police shootings and police excessive use of force in our country and in our state. We know that our country is devastated by the problem of police shootings, with hundreds of people being killed by police in our country. And we also know that people who are killed by police or subject to deadly uses of force are disproportionately people of color, young men of color. This is actually a leading cause of death. And in Maine specifically, it's very well documented that a large number of people who are killed by police have mental health disabilities and may be experiencing mental health crises at the time. So this is certainly an issue that we've been having national conversations about, and it's an important issue of public accountability of police officers who are taxpayer funded and government officials. And in Maine, there have been important steps forward in accountability, including with the creation of the Deadly Force Review Panel. But we also know there's continuing issues of concern. To this day, in recent decades, every single one of the Attorney General reviews of these uses of force has found that they are all justified. And that is a rate that does, when we see what's the conversations going on across the country, that is a clear rate that does strain credulity. And despite the important work and progress of the Deadly Force Review Panel, there are challenges that are associated with just the sheer length of the investigations that again, seem to come to this this almost predetermined outcome. And so because these investigations are so lengthy, it then delays the review by the Deadly Force Review Panel. And because of the way that the Attorney General's office has interpreted the Freedom of Access Act, it also has in the past, including in recent examples, delayed the release of dashboard camera video of the shootings. These dashboard camera police videos were intended to improve accountability for police and improve the ability for people to see what law enforcement is doing and not get sometimes a one-sided view of the story. So these videos have been critical in enabling people to see for themselves what practices police are using. So with that background, what this bill does is make two important, somewhat technical, but really meaningful changes to how the system works right now. And there's two basic parts. The first would create a presumptive time limit within which the Attorney General must complete review and send the information and investigation to the Deadly Force Review Panel. Now it's not set in stone, so there is still some flexibility worked in there, but by making sure that the investigation is completed and transferred to this sort of oversight body and investigative body, there's some it helps to ensure that these investigations will not languish, that it facilitates an important public conversation, and it ensures that there's going to be more eyes looking at these issues than just law enforcement focused review. So that's the first part. The second part would open up the dashboard camera video to more public oversight. So if there's a freedom of access request, there would be a greater ability now to get these videos in the language currently in the bill. And again, that's so important because we've just seen the ways in which video, which is a neutral witness to what happened, can completely transform public conversation about what is acceptable and what is not among our public officers in the police. And on the topic of the second point, the Freedom of Access Act, we have been in conversation with the Attorney General's office that has been very fruitful. I understand that the Attorney General's office has some concerns with the language as it's currently drafted, concerns there may not be enough flexibility in applying the standards. So we've been in conversations about how to make some technical changes to the bill to yield a result that ensures that there is the ability and authority for the Attorney General's office to release this type of information when it's in the public interest and without waiting for the entire investigation to be completed, but also having it be a little bit more flexible. So we haven't arrived at final language on that yet, but I believe that there is a good likelihood that we can come to an agreement on some solutions there. So with that, I will be very pleased to take any questions.
Thank you very much, Ms. Bond. Committee members, are there questions for Ms. Bond? Go ahead, Representative Harnett.
Thank you, Senator Carney. Good morning, Ms. Bond, and thank you for being here today. Do you have, I know it's difficult to predict the future, but do you have any idea when that language that's agreeable to all of the stakeholders might be available? I mean, I'm hoping it would be for a work session.
Yes, well, I can tell you that I've been emailing with the Attorney General. We've been sort of emailing back and forth language, and the gap is narrowing. So we do have words on the page. There's not yet 100% agreement, and I'm sure someone from the Attorney General's office is here and can provide their estimate as well on how far apart we are. But I would certainly hope and expect that, I believe attorneys do well with deadlines. So, when there's a work session deadline, I am confident, hopeful and confident that we would be able to meet that deadline with some proposed language.
And if just a follow up, and unlike courts, we do have deadlines because we only have till June 15th. So just obviously keep that in mind.
Understood.
Thank you very much.
Thank you. And Representative Moriarty?
Thank you, Madam Chair. Ms. Bond, I just want to review with you the sequence of events. As I understand, it begins obviously with a shooting, and then the AG begins an investigation almost immediately thereafter. Is that correct so far?
That's my understanding, yes.
But under current law, there is no time limit by which the investigation is completed.
That's right. And we've seen those investigations lasting longer and longer.
Okay. When it is done, however, does the report then go to the Deadly Force Review Panel next? And if so, is the report still private?
There are provisions in the Deadly Force Review Panel in subsection 6 currently, where the proceedings of the panel are not public. So I do think that the dual provisions of the current bill, which allow for a Freedom of Access Act, which is public disclosure of video and video evidence, which is again a very important issue for the public to discuss, as opposed to the entire report immediately going to, as opposed to everything that is before the Deadly Force Review Panel all becoming public. And the only other piece I'd have on that is the Attorney General, from what I understand, their decision is public. So when they complete the investigation, they issue a public decision. There's other materials that they have access to that is part of a complete file that is my understanding the Deadly Force Review Panel can review. So there's a few different pieces of information we're talking about here. There's the Attorney General investigation report, public. There's all of the investigative materials, some of which may not be public, that may go to the Deadly Force Review Panel. And then there's other items like video evidence or 911 calls that we would say, should be public records, and upon request, upon a FOA request, can and should be released publicly immediately, even before the investigation is complete.
Madam Chair, just have one more question to wrap up this sequence of events, if I may.
Yeah, that's fine. Go ahead.
Ms. Bond, when the matter goes to the Deadly Force Review Panel, do they have a deadline in completing their review?
I don't believe that I'm just looking at to double check my understanding. Within 30 days of the conclusion of the examination, the panel shall submit a report. Okay. So there is a fairly rapid deadline there.
All right, good. Thanks very much.
Of course.
I was muted. Representative Thorne, go ahead with your question.
Thank you, Madam Chair. Welcome, Ms. Bond. Thank you for coming and helping us understand this bill this morning. Just as a point of clarity, Representative Moriarty mentioned a shooting. It doesn't necessarily have to be a shooting, right?
That's correct. It's any use of deadly force. So okay. That could be a variety of types of force. Often it's a shooting. Yeah.
And I'm just curious what constitute, if there's a list, I don't see it here before me, what constitutes deadly force. In other words, if somebody restrains a suspect and performs a maneuver that normally wouldn't kill somebody, but maybe because they had drugs in their system or they were unhealthy, they died. So is it fair to say that if a suspect dies in custody, that would necessitate a use of deadly force?
Yes. So this has been a subject of, as we've been discussing the inner workings of the bill, we've definitely been discussing, deadly force that is in fact deadly, deadly force that may not be deadly in a particular instance. But I think it's very safe to say that in an instance where someone does in fact die, would and should be treated as an instance of deadly force. I suppose there's always the outside possibility that a person dies in the course of a police interaction that, for reasons unrelated, but that I do think that's quite a hypothetical that hasn't really been presented as a real matter of concern here. I do think if someone dies during a police interaction, during a police use of force, that would and should be counted. There are definitions of the types of force that are considered to be a use of deadly force. So that would, of course, be the first line of inquiry. But when someone does die, I do think it's important to have that go through the process of the deadly force review panel.
Thank you for clarifying that. Thank you, Madam Chair.
You're welcome. Representative Sheehan, go ahead.
Thanks, Madam Chair, and thank you, Ms. Bond. This might be a difficult question to really answer, but you had mentioned that the initial review by the AG currently has no time limit, and that the reviews are taking longer and longer. Is there sort of a range that you've noticed? Maybe like what are the longest reviews versus ones that, like what would we expect of like a very short review by the AG?
Sure, I'll do my best to answer that. And I do suspect the Attorney General's office could provide more detail about it. And I'll just share one example of actually how I think I got involved in this issue and why it is that Representative Talbot Ross had asked me to be involved in this bill and present on this. And there was, as the committee may remember, the issue of the shooting in Minot of a man who was unarmed, and that drew a lot of attention. There was a concern about there was video camera evidence in that case that was requested by a family member and was not released during the pendency of the investigation, and the investigation took longer than 1 year. So there was this concern that this was a case of sort of, a concern about justice delayed being justice denied, and where these conversations about police accountability being so prevalent across the country and so important and critical, and this really being an extended investigation, I think added to the concern that all of the investigations have resulted in the same outcome of a finding of justified. So I'm sorry I can't provide much more detail, but that's an example of quite a lengthy investigation. And it's my understanding that that's not particularly an outlier, although there have been many efforts internally, from what I understand, to find ways to address the backlog. So it's not for lack of trying, from what I understand, but I do think that a presumptive time limit and imposing some, legal limits, at least presumptively, would be helpful to address the concern.
Thank you. That's helpful.
Yeah, thank you, Ms. Bond. I think you've answered all of our questions. Let me just check in. Representative Babbage, is your hand up anew?
I was just going to say, asked and answered, Madam Chair. It's not an objection. Thank you very much.
Thank you. There's another question. Representative Evangelos, go ahead.
Thank you, Madam Chair. Good morning, Emma. I just wanted to ask you if were you aware of the backlog of cases that the current Attorney General inherited from the previous Attorney General?
Yes, I understand that there has been a backlog, yes.
And I'm hopeful that when he's able to get caught up on those cases, it's not an easy task, that the time limits outlined in this bill will work. And I'll leave the rest for the Attorney General. Thank you.
Thank you.
Committee members, I'm not seeing any additional questions. Ms. Bond, thank you so much for presenting all of this important information about the bill today. And I understand that you have other obligations this morning, so I'm going to send you to the attendee space and then you can sign off. And once again, thank you so much for being here.
Thank you.
At this point, I'm focusing on the attendee portion of the meeting and asking anyone who is here to speak in favor of LD 1480 to please raise your electronic hand, and please keep it raised until you've been called upon and had a chance to speak. And we'll start with Attorney General Aaron Fry. Welcome back to the Judiciary Committee, Attorney General Fry.
Good morning, and thank you for this opportunity to be with you. Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Aaron Fry. I live in Bangor, and I have the privilege of serving as Maine's Attorney General, and I'm testifying in support of 1480 this morning. As you all know, this legislation really does two things. It establishes a time frame in which the Attorney General's office has to fully investigate and turn over its findings to the Deadly Force Review Panel. And it also provides an amendment to the public access laws with respect to video recordings depicting the use of deadly force by law enforcement. So first, I support establishing a reasonable length of time to complete an investigation into the incidents of use of deadly force by law enforcement and submitting those findings. Investigations into the use of deadly force requires multiple interviews, evidence collection, analysis, law enforcement review, prosecutorial review for legal determination. These investigations really should be completed no sooner and no later than is necessary to ensure a complete review. But that said, we've talked a lot about this in the office, and we feel confident that we would be able to address these cases within the timeframes that are outlined within LD 1480, which is 180 days. If there's an issue that makes it problematic to get it within that time frame, then an extension to 270. As for the current backlog, I did provide an attachment that outlines something that I had released back in February that might be of some interest to committee members. I had published that back in earlier this year. Second, with respect to the release of video recordings, first, this is cruiser cam, body cam. I mean, this really would be any video that is within the possession of the state. I'm generally supportive of providing more prompt access. I did suggest to the sponsor a more tailored approach because LD 1480, what it does is it makes all video non-criminal record. So there's no protections at all as it's written now. I appreciated the willingness of the sponsor to talk with me about that and consider a more calibrated approach. As I believe folks heard from Emma Bond, we have been engaged in what I think were good faith, productive conversations. We have exchanged language, and I don't know that we are terribly far apart. And so I do expect that a proposal would be ready by a work session. Frankly, I also would benefit from hearing from people today, hearing the committee's questions, hearing the public's information, because I think that'll inform that process too. So that's the testimony I have for today. Certainly happy to work with the committee today, at the work session, outside of this. The only thing I want to add is Representative Moriarty had asked a question about the timelines for the Deadly Force Review Panel. That 30 days is the release of the report once the conclusion has been made. There is no time frame once a case is submitted to the panel. There's no time frame for the Deadly. Thank you very much.
Thank you, and thank you for preemptively answering Representative Moriarty's question as well. We have a number of questions from committee members. We'll start with Representative Sheehan. Go ahead.
Thanks, Madam Chair, and thanks for being here, Attorney General Fry. This is a pretty, hopefully, quick question, and I know that you said that conversations are ongoing, but when you talk about a more tailored approach to access to video footage, on what kind of criteria would you want to tailor it?
Thank you, Representative. The items that we are looking at to build in are a clear time frame within which the information, the request would have to be responded to. 30 days, 45 days, right? And if for some reason there were clear privacy interest, because these videos, it's not just the officer and the individual who has been the subject of the deadly force, it's victims, it's members of the public. I was reviewing a case recently where the video contained more graphic material because of the treatment that the individual had been receiving on body cam. I think everybody would agree that that kind of information is not appropriate to distribute. It doesn't go to the question of why the force was used and whether or not it was appropriate. That's just a flavor of what it is when I talk about tailoring. Clear timeline, understanding that the release of this information does have significant public value, but also recognizing there are some interests that that we need to protect. That's where I think there has been agreement on, in principle, on sort of what has to happen. Additionally, to the extent that there is something that's clearly needs protecting, there would have to be a more specific articulation by the Attorney General about why it's a problem. So right now, the practice has been there isn't a thorough, specific explanation as to why the video might not be eligible to be released. Making sure the public understands the why, and then how long it's going to take to get on the other side of that why. That's also what these tailoring conversations have included.
Got it. Thank you.
Thank you both. Representative Babbage, you want to go ahead with your question, please?
Thank you, Madam Chair. Good morning, Mr. Attorney General. To piggyback on Representative Sheehan's inquiry, is it privacy alone, or I need for you to help me to understand the implications of, I think you said, making the video a non-criminal record? Are there legal implications, or are we talking privacy issues primarily?
Well, so the two, and I don't know if I did include this in my written testimony. Really, the two considerations that we're thinking about mainly are privacy and the integrity of the criminal case that may develop as a result of a use of force. The way that the language is written in this bill, it completely removes any protections at all for any use of force, not just deadly use of force, but any use of force whatsoever by law enforcement. What has been my experience in the short time that I've been Attorney General, there are instances where because of the compromising position that the subject is in, because of victims who are involved in the incident that leads to the use of deadly force, it is primarily if I'm going to bring a case, I need to make sure to protect it. If there are victims or compromised subjects, I need to make sure to be able to protect them. So I don't know if that's fully responsive to what you're asking, but that's what I've been thinking about when talking about why I think we still need some ability to protect some information.
I guess, if I may, Madam Chair, I'm not fully cognizant of the.
Representative Babbage, I'm sorry to interrupt you, but if it's a follow-up question, go ahead. And if it's a comment, we'll save that for the work session.
Yes, I appreciate that.
Thanks.
I'm unaware of discovery, but when you say legal implications of the video release, I'm not sure if I understand what would not be accessible by defense, for instance.
Well, so to the extent that there's some sort of criminal proceeding that involves a subject connected to the use of deadly force by law enforcement, there is a separate process, a separate criminal process where discovery rules and rules of court, case precedent right, the Constitution require that information be shared with defense counsel, right? I think here we're talking about the release of information to the public and ensuring that that release of information doesn't compromise what may very well be legitimate state concerns.
Okay, I think I understand your argument. Thank you very much. Appreciate it.
Thank you, Representative Babbage. Representative Rickett, go ahead with your question.
Thank you. Good to see you, Attorney General. My question has to do with personnel and process in your office on these issues. When we say to somebody, you have this much time, how many people can be thrown into such an investigation, or is this a one-man show or one-woman show? You know, what size numbers of people are we talking about taking care of this particular kind of issue?
So the way these investigations work through the office, I'd put it in 3 different stages, right? The first is law enforcement is required to call the Attorney General's office immediately or as close to immediate to the use of deadly force, the deployment of deadly force by law enforcement. We send an investigator, at least one investigator. There's a primary, but it typically is multiple investigators will go to the scene, secure what they, secure for evidentiary purposes, interview the officers involved and other witnesses in order to get as close to the time as possible information about what's going on. We have 4 people, 4 investigators who are trained to do, these are homicide investigations, right? In most cases.
Mm-hmm.
So we have 4 people who are trained to do that. And so one of them might be the lead, others might be involved. After the investigation is completed, that is to say, doing all the interviews, collecting all of the available evidence, so getting the body cam, getting the cruiser cam, getting any audio, getting any 911, that is not immediate. That takes a little bit of time to collect all that from the different agencies that might be involved. It's reviewed, processed, and handed over to the chief of the investigations division, who ensures that the investigation has been complete, processes it, sends it over to the homicide prosecutors. That's the second step. It's in that second step where the case is reviewed for a recommendation to be made to the Attorney General. Once the recommendations have been pulled together, the file is all complete, it's forwarded to, in this case, me, and I make that third stage, I make that determination, that legal determination about whether or not the use of deadly force was justified according to the statutes. So in terms of the resources involved, we have the 4 investigators who are trained to do that. You have the head of the investigation division who is part of that process. Right now, I have not 1, but 2 different homicide prosecutors who are reviewing these cases in order to try to prioritize moving these, getting caught up. And then, of course, I review the complete file. So that gives you the sense of the resources involved.
Thank you so much.
Representative Thorne, you can proceed with your question, please.
Thank you, Madam Chair. Attorney General Fry, I'm trying to understand this bill. What does this do that you don't already have in place? I mean, I would assume that anybody that dies, there's going to be a complete investigation. So what does this bill propose to do that you don't already have the ability to do from your standpoint?
Well, with respect to the time frame, these cases have been ticking up. We did our own analysis going back a couple attorneys general, and gradually the numbers were climbing. So the lowest amount of time that it took for a case to be processed from start to decision was 73 days. The most that it took was 548 days. That's a range of timeframes for these cases to be processed through. Understandably, each case needs to be considered on a case-by-case basis, and so there isn't a fixed amount of time that it should be done in. But in the office, thinking about how long it really should take from start to finish, we didn't think, frankly, it would take longer than 180 days. once we get caught up, right? The challenge is that, there is catching up that we need to do right now. What the first part of this bill does is ensures that there is not a backlog again, so that we don't see that ticking up of time that it takes to address these cases. The second part of the bill really recognizes that there is an increased level of public interest and call for transparency in what is the most significant uses of force by the government. And we have certainly seen across the country how material has been able to be released. And we haven't seen the problems coming from that our present law recognizes or suggests there might be. So the summary answer, I appreciate listening to all that. The summary answer is the first part of the bill makes sure that we don't have a backlog again, and that's not an unreasonable time frame. The second part of this is prioritizing the expedient release of material to the public so that they can look at how force is being used by law enforcement.
Follow-up question, if I may, Madam Chair.
Go ahead.
Attorney General Fry, is it possible that in the rush to meet a deadline that things may be missed or overlooked in an attempt to meet the deadline set with this process?
Given that my own rushing has caused problems before, I can't say that that's not true, but let me add something that I think is important to this analysis. So the Attorney General's office does its investigation and provides one set of eyes for review. There's a second process that's undertaken by the agencies that involves a 5-member panel that's, I think it might have even been directed by statute. There's a 5-member panel that's convened to have eyes on this case to determine whether or not the officer complied with what the officer was supposed to be doing. There's a third set of eyes on this case by the Deadly Force Review Panel, who is also looking at this situation to determine whether or not everything that was supposed to be done was done, and if not, what could be done differently. And then there's a fourth potential hands-on, which is it's not uncommon that there'll be a civil case involved in which a family members or the subject of the use of force may bring their own civil case, and that provides its own transparency. There's a fifth, which is the public. I put every single letter that I've issued, and I've made sure that every single letter that this office has issued available, I post that online so that people can take a look at that. People can, but don't always have the ability to request records to make their own analysis of how well done that review was. So there are many different opportunities to ensure that the process that's employed to investigate and come to conclusions on these cases doesn't miss substantive relevant factors to the use of deadly force by law enforcement.
And these various ones could be going on simultaneously, correct?
Well, they are. Yeah, in fact, they are. So I mentioned the law enforcement, the panel that the agency puts together. That is typically going on at the same time as the Attorney General's office review, right? So it's in tandem, and they have access to the same information that the Attorney General's office has.
Thank you for that. Thank you, Madam Chair.
You're welcome. Representative Evangelos, go ahead.
Thank you, Madam Chair. And good morning, Attorney General. I can attest that he's been working hard today. We were exchanging emails between 5:30 and 6:30 this morning. In reading the reports of the Deadly Force Review Panel, I've been pleased by the frankness and the thoroughness of the results. And on at least a couple of them, it led me to the question that, do you think we should have, when we set up the panel, it was a good compromise, but it fell a little short of my expectations. But do you think after we've read these reports that there should be a process that would have allowed the panel to weigh in as to whether the specific incidents in these cases were justified or not?
So I'm not there yet, but that's not me giving the answer of a hard no. I do think that the Deadly Force Review Panel has provided an excellent substantive review of the cases that have been presented so far. It took a little bit to get it set up in 2020. It's cooking here in 2021. I think it's going to have some much more substantive considerations that will be presented to the legislature in its annual report. And I think you're going to see recommendations about enlarging the panel in terms of the membership to bring in maybe a more diverse point of view on the membership. I know that I've already been engaged with the chairs about what resources we might try to engage to help them better communicate where they're seeing deficiencies, where they're seeing things working. Frankly, the conversations that have been occurring are already leading to some re-examination at the law enforcement level. So case in point, myself, Deadly Force Review.
Attorney General Fry,
Yes.
I'm sorry to interrupt you, but it sounds like those are recommendations that will be forthcoming, and we try to wrap up our work by 12:30 on Fridays. And I also am very interested in what you're saying. I hope that you'll bring it back to us when we have a chance to act on that information. Thank you so much for answering Representative Evangelos' question. Representative Evangelos, are you all set?
No, I have some more questions. I indicated I had several.
Go ahead.
It's an important topic, Madam Chair, and the Attorney General and I have been working on this for a long time, so it's important I be allowed to.
Go ahead with your next question, please.
So what about giving more consideration to the actions of law enforcement that contributed to the escalation of the incident? I know, specifically in a couple cases, we witnessed a mental health check at one location where an armored personnel carrier showed up, and that certainly didn't help that person calm down. And then in the Gora case, the initiation of a high-speed chase for somebody that was suffering a mental health episode when the family had called in. Can there be more consideration given to the fact that mistakes by the police contributed to the use of deadly force? And it doesn't seem to me that mistakes by the police end up in an unjustified ruling. They make mistakes and push somebody over the edge, and then they rule it justified. What do you think about that?
I'm just going to interrupt here because I agree with you so much, Representative Evangelos, that is a really important issue, and it's something that we've been considering in other bills. But this bill is really about timelines on investigations and access to video recordings. And in order to allow our committee time to get to those other bills, we really need to focus on the bill that's ahead of us. And so if you could proceed with a question related to this particular bill, that would be really helpful. Thank you.
Okay, I'll take it up with them at another time. The last question, and it's a specific timeline question. Attorney General, you mentioned that there was a case that was just 73 days. Was that the Jackson case?
No, that was a October 23rd, 2012 incident in Lemoyne. That's the case that I was referring to at 73 days.
Because I know Jackson was shot on September 23rd, 2007, and I believe Attorney General Rowe made his ruling in November of that same year.
Perhaps that's something you could bring back to us for the work session, that specific timeline.
Well, that's less than 73 days. So.
Just so the committee knows, I went back to January 15th of 2011, so that I did not go back to 2007 for this analysis. So I can go back further to find timelines for the committee.
Yeah, just on that specific case, we know the case. So thank you.
Thank you, Representative Evangelos. Thank you, Attorney General Fry. Go ahead, Representative Harnett.
Thank you. Thank you, Madam Chair. Welcome. Attorney General Fry, nice to see you. In your testimony and your answer to questions, you recognized, as is pretty evident now, that there's a sea change going on around the country on this issue about releasing videos. And we are seeing videos being released within 24 to 48 hours of incidents involving the use of deadly force in very many states and in very many large police departments. What makes Maine different in as to why these videos should not be released immediately? I just don't understand that.
Well, so first, I don't know that we always have all of the material within that time frame, right? So I mean, in terms of getting the video and being able to be responsive, there was a use of deadly force in, I believe it was Livermore Falls recently. We got an immediate request for material that we just didn't have yet. So just in terms of the, so that's one clear reason for the timeline. The second reason is that's where I need some help, right? Because I look at this video, I've been asked to apply Title 16, 804 to that. And I need to, if I find that there's a reasonable possibility that that information may do one of a number of things, in terms of the ability to release it, as I hope you understood from me today, I do think that there could be a more expedited timeline. I have a commitment from the team to be able to review the material promptly upon request. And so so that's an answer that might be a non-answer. I don't know how other states are processing this material. I don't know what their laws provide. Not all states do this, right? So other states we could probably look to are more draconian in how they release this information. I do think it could be released sooner. I don't think it would have the kind of impact that 804 is concerned about it potentially having. And that's why I'm trying to be a partner with the sponsor and with the ACLU at getting to a more prompt release of this material.
Thank you. Thank you for that answer, Attorney General.
Representative Moriarty, go ahead with
Thank
your
you, Madam Chair. Good morning, Attorney General Fry. I have a clarifying question that goes right to the heart of one of the more significant parts of this bill. And I'll phrase it this way. Assume that there was the use of deadly force in an incident and there was a video recording. Under current law, as it stands right now, can that recording be released, or what are the conditions under which it can be released?
The answer is yes. The considerations are found under Title 16, Section 804, which provide that this type of material is to be released unless there's a reasonable possibility that it would. And then it lists, I think it's 12 different, it's 12 different, interfere with a criminal law enforcement proceeding, result in dissemination of prejudicial information, constitute invasion of privacy. So it can be released now, but a consideration has to be made as to whether or not there's something that exempts it from being released. And again, that's Title 16, Section 804.
But thanks, I have it. Thank you then.
committee members. Any additional questions for Attorney General Fry? Go ahead, Representative Evangelos.
Thank you, Madam Chair. So in the Attorney General, in the statute you just referenced, you do have the discretionary authority to determine whether, defining that word interfere, whether you can immediately release the videos that Representative Harnett referred to, right? You do have the authority to move quickly.
Yes, the discretion is built into that decision-making process about whether or not one of those factors is implicated. So yeah, it is what I'd call a prosecutorial decision.
Thank you.
Looks like there are no further questions for you, Attorney General. Thank you so much for being here today and for all of your answers to our questions. We'll bring over the next person who's here to testify, Dan Chase. Oh, he's here twice.
I'm only here once, actually.
Okay, great. You're on our screen twice. I'm going to take one of those down, but you can proceed with your testimony, Mr. Chase. Welcome.
Thank you. The Attorney General's office is the wrong place to do this. I called up the Attorney General's office and said, I have a complaint against a state employee. The woman on the phone told me that their job is to protect state employees. Want to know why you have a problem? That's it. They don't believe they're supposed to find employees guilty. They believe they're supposed to find them not guilty. They're supposed to protect them. That's their job. When they were given information about a state employee committing crimes, they refused to even investigate because that wouldn't protect the state employees involved, would it? What you need to do is get this away from the Attorney General's office and create a new office. Jim, I may have talked to you about this before. You need to have an office of police accountability. You need to have an office that says, we will hold police accountable. It needs to be not just for deadly force, ladies and gentlemen. It needs to be for all force that has a complaint against it. The police have this thin blue line, the blue wall of silence. The Supreme Court calls it strategic deception. It just means that they lie and they cover up. You can't get rid of this when you keep it with somebody who thinks they're supposed to protect the police. The police do not have any more right to attack somebody else than I do. The people created the state. I don't have the right to use deadly force against somebody the way the police do, so I couldn't have given it to the police when I created the state. Well, my ancestors, you know what I mean. Now, Tom, you're a lawyer, you know this.
Mr.
Three
Chase,
axis of law. From nothing, nothing comes.
I'm going to ask you to stop speaking for just a minute, if you could, please.
Pardon?
It's not appropriate for members of the public to call out committee members specifically by name during their testimony. And in addition, you raised your hand to indicate that you were here to testify in support of LD 1480. I think you probably have a minute or so left in your testimony. If you could directing your remarks specifically to LD 1480, we'd appreciate it. And you can go ahead and proceed for the remainder of your time. Thank you.
First Amendment, I call anybody like I like. Second, I'm in favor of the idea. You just have to put it to a different organization than the Attorney General. The idea of having police accountability is necessary, but it needs to go further than what's done in this bill. If I call Tom, Tom, we've talked. If I call Jim, Jim, we've talked. If you tell me that I don't have the right to engage in the First Amendment, you're violating my rights, and I don't appreciate that. We have the 9th and 10th Amendment to respond to people by name. You want to be separate? I'll call you whatever the hell your last name is. If you want to be accountable to the people and have the people feel we can talk to you, remove that separation.
Remove you because you're violating the decorum of the committee meeting and you're not addressing the bill. We appreciate you being here.
I addressed the bill.
And our next person is Dale Boise, I believe his name is. Will be joining us momentarily.
Hello.
Hello, welcome. I'm sorry I called you Mr. Dale.
My mail comes Mr. all the time. When I was younger, I got put into a boys' gym class. Was later in life might not have been bad, but in 7th grade it was quite embarrassing. So I answered to most anything. Good morning. My name is Dale Boyce, and I remember from the last testimony, I need to say my town. I'm from Standish, Maine.
Thank you. Proceed.
I'm here in support of this bill, and I have lived this nightmare, as I'm sure most of you are aware, and hopefully you received my emails. I kind of picked out, but you have to remember, I wrote every single Friday to Brian McMasters, begging, pleading. I tried everything I possibly could to let him know that my family was being destroyed with their timetable. I did research. I found, the Attorney General didn't say, but it's mostly over 2 years. before a conclusion is come to in this state. That's unconscionable. We only wanted the truth. That's all we asked. We didn't say, we had no preconceived notions that it was going to be an unjustified shooting. We knew it was going to come back justified. It always, always does.
Yeah.
I do think that we need to have that review board, the Deadly Force Review Board, look at it from different eyes than from police. I do hope that this committee or review board has everyday citizens in it. It is always, their report is always geared toward the police. And if you've seen some of the video, because of course it is redacted, so you're not seeing the initial final shooting and killing of my nephew, but you will see that they were chasing him and continued to chase him, first with cars, then on foot, yelling, cursing, swearing at him. That was not de-escalating, taking him down from this fear that he had. I'm hoping that this bill, within that time frame, shortens that. It is a painful, painful time for my family that we went through. I hope you take the time to read those emails. His mother was devastated. My brother, I thought, would die. I worried so much about him. He just needed answers. Good answers, bad answers. He needed to know what he did wrong by calling the police. What did he do wrong? He reached out to who he thought was supposed to save his son, and they killed his son. But no one would tell us what happened. I always got, well, it's the law. It's the law. I can't tell you anything. It's the law. And it had not been for the pressure of John Chrysos, I thank him so much for showing this case. Senators, Timberlake, Jeff Evangelos, others that reached out to me and said, yes, this is unconscionable. This shouldn't be this long and open-ended. And then at one point I was even told, well, I'm just a number in a pile. I felt like the deli. I had no idea how long I was going to have to hold my family together.
Ms. Blah, the 3 minutes is up. We just want to thank you for presenting your testimony today.
Please read those emails.
Thank you, we will. And Representative Evangelos, I believe, has a question for you. So hang on just a moment. Go ahead, Representative Evangelos.
Thank you, Madam Chair. Just very briefly, Dale, I just wanted to express my sorrow to your family. I'm very sorry. Thank you.
Thank you. We live with it. We're learning to live with it and move on with our grief, but we have still a lot of questions. But thank you for caring. I just needed somebody to care. I couldn't find it at the Attorney General's office, no matter what I pleaded.
Thank you, Ms. Ball. We appreciate you being here today.
All right, thank you.
Thank you so much. And with that, I don't see anyone else with a hand raised in support of this bill. And so for those who wish to testify in opposition to the bill, please raise your electronic hand and keep it raised. So first we have Chief Roland LaCroix. And welcome, Mr. LaCroix. Chief LaCroix, you can activate your audio and video and proceed when you're ready.
I cannot activate the video. I apologize.
Let me see if I can do something on this end.
There we go.
Go ahead. Welcome.
Thank you, Senator Carney, Representative Harnett, and members of the Judicial Committee. I know I'm a last-minute addition, but we certainly appreciate it. My name is Chief Roland LaCroix. I'm the chief at the University of Maine and the current president of the Maine Chiefs of Police Association. The bill entitled An Act Regarding the Review of Law Enforcement Use of Deadly Force, the title accurately enough describes the first of the two sections of the bill. The Maine Chiefs of Police have no objections to Section 1. Section 2, however, is much broader and has much broader implications. It amends a different title of Maine law concerning what is deemed to be intelligence and investigative record information. Current law 16, as the Attorney General referenced, 16 MRS 804 places restrictions on the release of information if the result would affect the following. And I think you have the written testimony. I will not go through the list of 12 items that it is that the Attorney General referenced. We would submit that these are reasonable, important restrictions on the release of investigative information. Section 2 says that if the information happens to be in the form of video recording, it should not be considered intelligence investigative record information, regardless of the consequences of its release. We therefore oppose Section 2 of LD 1480 as written. We are not opposed to greater transparency when law enforcement officers use physical force, but Section 2 effectively eliminates confidentiality of images or information contained in video recording. The consequences of this would be no different than the result of any other police record or document being stripped of the very legitimate exceptions to public access in current law. While body-worn cameras and cruiser cameras provide significant measure of accountability and are helpful in enhancing relationships between the police and community, the technology is also an effective means of documenting evidence. When this evidence is disseminated publicly, there is reasonable possibility that it may be harmful in compromising an investigation or prosecution prematurely, disclosing information prejudicial to an accused that denies an accused constitutional due process or taints a potential jury pool. More importantly, the very legitimate private rights of all citizens, including complainants, victims, and witnesses, rights and interests historically recognized in law, simply vanish with the adoption of this proposal. With no legal authorization to redact such portions of a video, the identity and activities of even innocent persons become a matter of public consumption by simply making a freedom of access request. Much of the information of images on such a video may be unrelated to an event involving a law enforcement use of force, and that these cameras are filming uninterrupted for what may be an entire shift of an officer, capturing involvements in a series of events, some of which are fundamentally unfitting, if not unconscionable, to expose publicity. Again, we support.
Chief LaCroix, the 3 minutes has passed.
Okay, thank you.
Let's see if there are committee member questions for you. I see Representative Evangelos. Please proceed with your question. And you're muted, Representative.
Thank you, Madam Chair, and welcome, Chief. The statute that you're referring to, Title 16804.
It looks like Representative Evangelos is having some connectivity problems. Representative Moriarty, why don't you proceed with your question and we'll go back to Representative Evangelos in a moment.
Okay, thanks very much, Madam Chair. Good morning, Chief LaCroix. Regarding Section 2 of the bill and your objections to it, you just refer to the fact that a body cam may be running for the entire duration of a shift, and therefore only fragments of it may be pertinent to the use of force. As I read the last sentence of Section 2, it refers to a video recording of the use of force by a law enforcement officer. It seems to me that the disclosure provisions provide, or rather relate only to that percentage or portion of the video that records the use of force, and not the whole day in the life of the officer on that particular shift. What are your thoughts in response?
Well, as the Attorney General said, it should only apply to the use of force that was used to establish if it was excessive use of force. We don't believe anything else is captured on there that would apply to that. Yeah, because the biggest issue is the privacy issue. In my opinion, it is.
Okay, thank you.
Thank you both. And Representative Evangelos, you're back. Go ahead with your question.
Yeah, I'm in the State House, sir, in the State Office building. I don't know what the problem is.
Yeah, it froze, but we're glad you're unfrozen.
All right. Thank you, Chief, for your testimony. I did want to pursue Title 16, Section 804. Paragraph 3 does discuss the invasion of privacy issue. I have two questions. In a case where the family of the victim who has been lost their lives due to the use of force, in the case where the victim surrenders the right to privacy and asks for the material to be released, are you supportive of that?
You're talking about in an investigation?
Well, I'm talking about the law you cited, Title 16, Section 804. You mentioned the privacy concerns. If the family waives their right to the privacy issue, would you be supportive of the release of the videos then, on the grounds that there is no longer a privacy issue?
Well, I cannot, I can't comment on the procedures of the investigation. I just, that would be, what you're talking about is actually fundamentally changing the law. So, I'm really not prepared to be able to answer that, Representative Evangelos.
Did you have another question, Representative Evangelos?
I did, but I want to think about it. And if I lose my chance, that's my tough luck.
Okay, thank you very much. Thank you, Chief LaCroix. I'm not seeing any other questions for you. The next person who has signed up to testify in opposition is William Ross. He'll be joining us momentarily. Welcome to the Judiciary Committee, Mr. Ross, and you can proceed with your testimony when you're ready.
Thank you and good morning to everybody. Senator Carney, Representative Harnett, distinguished members of the Judiciary Committee. My name is Major William Ross, and I'm here to represent the Department of Public Safety, the Maine State Police, to testify against LD 1480, an act regarding the review of law enforcement use of deadly force. The use of deadly force by a law enforcement officer is one of the most difficult decisions a person can make. This decision can occur in a split second where a law enforcement officer is defending themselves or another from death or serious bodily injury at the hands of another person. The facts and circumstances surrounding deadly force incidents can be complicated and require a thorough investigation by experienced individuals. These investigations can involve multiple interviews of witnesses, evidence collection, evidence processing, and review of video and audio recordings from the actual incident. These investigations require time to ensure a comprehensive approach has been taken and all facts have been established before a finding can be determined, regardless of the outcome. Compromising the integrity of a deadly force investigation, or any other investigation for that matter, would taint the results or findings of such an investigation. The proposed legislation would exclude from the definition of intelligence and investigative record information a video recording of the use of force by a law enforcement officer. Currently, the release of this information is confidential and for good reason. It protects the integrity of the investigation. The premature release of any video or audio recording, evidence, or other facts of the investigation can have a detrimental effect on other aspects of the investigation. Imagine if a partial video recording of a deadly force incident is disseminated on the various media platforms available today before the investigation has concluded. This could influence potential witnesses yet to be interviewed or lead to evidence being destroyed. The release of such material could create a false public narrative, interfere with the trial process, or fail to protect the privacy of complainants and victims. In Maine, the Attorney General's office is tasked with investigating the justification of the use of deadly force by law enforcement officers. That process must not be compromised for the unbridled release of video recordings and deadly force incidents involving the police. The individuals directly involved, to the public we serve, protecting the integrity of these investigations is crucial to obtaining the most comprehensive report and eventual finding, regardless of the outcome. For these reasons, I strongly urge the committee vote ought not to pass on this bill. On behalf of the Department of Public Safety and the Maine State Police, I thank you for your time today, and we'd be more than happy to answer any questions.
Thank you very much, Mr. Ross. And there are a number of questions. Representative Thorne, you can proceed with your question.
Thank you, Madam Chair. Welcome, Major Ross. Appreciate you being here today, helping us understand this bill a little more. I think what I'll do is I'll hold my questions for the work session, but I'd like to request that Major Ross be available during our work session to help us understand some of the intricacies behind release of the video and current standards.
Thank you very much, Representative Thorne. We'll send him an invite to the work session. Representative Evangelos, I think you were next.
Okay, Madam Chair. Welcome, Mr. Ross. A little earlier today, Representative Harnett made reference to what the reforms that are sweeping the nation. So is it your testimony today that you are not supportive of the prompt release of these videos that many police chiefs around the country are undertaking to do right now?
Thank you for the question, Representative Evangelos. My testimony is the integrity of the investigation must be maintained. The actual release and the decision to release this information, as long as it complies with current law, is fine as long as it doesn't taint the integrity of our investigations or the Attorney General's investigations, depending on who the lead investigator is. That's my biggest concern, is that when this information is available, and certainly supportive of it being available on, with respect to the law, that it doesn't hinder the investigation or interfere with witnesses, interfere with potential issues that could come up in a trial or anything the prosecutors may be working on. So it gets involved when this information gets out there, and it affects and potentially can hinder the investigation of either the law enforcement agency, the Attorney General's office.
So you're not necessarily opposed to the release of this material prior to the conclusion of the investigation. You're saying that it's a case-by-case basis.
Well, I think everything is a case-by-case basis. I think we have the existing law is what will determine certainly what we do, and the attorneys general, they'll make those decisions. They have that discretion. In cases involving, say, non-deadly force, where their use of force was used, certainly we'll be deferring to the prosecutorial authority to make those decisions.
Thank you.
Senator Keim, go ahead.
Thank you, Madam Chair. Thank you, Major Ross, for being here. One of the things I agree with some of the things you've said about the issues around releasing the videos. What I cannot understand, and I don't know if you can help me with this, but I don't understand the difference between those hesitations, which are valid concerns, and what we're seeing where in other parts of the country, this video is being released almost within a day or something. Is there any way you can help me understand how this works in other states, and how it isn't maybe interfering with investigation or witnesses and all the rest, and yet here we're considering those things? Is there any way you could help me understand that?
I can touch on that. I don't think I'm going to have a great answer for you, Senator Keim, because I don't know why other states, agencies in other states have come to that decision. Certainly, like in Maine, the Attorney General has that type of discretion. Agency heads certainly have that type of discretion. And speaking for investigations that I've been involved in, Maine State Police has been involved in, that if they are going to interfere with the investigation or challenge the integrity of our investigations, that would be something that we would not be in support of, getting those videos out in the public eye prematurely. I think there's a time and a place for it. But as to why other parts of the country have made those decisions, I don't know the particulars of those individual cases, and I wouldn't want to comment directly on that.
Thank you.
Committee members, any additional questions for Mr. Ross? Go ahead, Representative Babbage, with your question.
Thank you, Madam Chair. Mr. Ross, thank you for being here. Can you explain to me I of the 12 intelligence and investigation record information exceptions there, impaneling an impartial jury is one consideration that would have long-term consequences, but has evidently been overridden by many other states as a primary concern. So what I'm asking is, are you talking about the ability for the AG's office to examine witnesses and get depositions prior to public opinion being formed?
I think, thank you for the question. I think when in generally speaking with investigations, if certain type of information is released, sometimes you don't have control of it, but the information that you have as a result of your investigation, if that information is out and there's, let's say, for example, that there's witnesses that haven't been interviewed yet, and they obtain this information, they see it on television, they hear it on the news, that can taint their view of what they saw, what their part in the actual event was. And as investigators, I would like time to get to those people before any of that information is put out to them, so I can get probably the most clear idea and capture what they saw at the actual event versus this influence from either a media source or, you know, it's some other avenue that they've obtained this information from. Once that happens.
So if I may, so would you support a very short window in order for those investigations, in order for those interviews to take place?
No, I think you have to let every investigation is different. You could have an incident that's, you know, contained in a very small area, involve one or two people, and it really isn't that difficult to determine what happened, and the timeliness of it could be a fairly quick turnaround. You have other investigations that are extremely complex that involve multiple interviews, collection of evidence, crime scene processing, evidence that has to be processed at lab, ballistics, and if you're talking police-involved shootings, there is a lot that happens in these. And to put a time constraint on the investigation, that would be something we are not for. The state police would not be for that. I just want to make clear that in terms of the time frame that the Attorney General's office has, we would defer to the Attorney General with respect to the first part of this proposed legislation.
Thank you, Mr. Ross. Thank you, Madam Chair.
You're welcome. Committee members, any additional questions for Mr. Ross? Not seeing any. And I'm just looking in the attendee space. There's no one else who raised their hand to speak in opposition to this legislation. But I do see one person who wished to speak in support of it, who I missed initially. So I'm going to bring him over, and then we'll call the neither for nor against. I just lost him. There we go. And for those in the attendee space, if you could please raise your hand if you're neither for nor against, then we'll reach you shortly. And Mr. Danziger, you signed up to testify in favor of LD 1480. You can begin your remarks, and welcome to the committee.
Thank you to members of the Judiciary Committee. My name is Larry Danziger. I live in Bangor. I submitted testimony in support of the faster timeline for reports. In addition to that, I have several other items in the testimony I want to mention. One is that there is no national, or in the case of Maine, state use of force policy. I think there should be a state use of force policy that several other states have adopted already. And there is a couple of sources to get started with that.
This bill is about the timelines.
Yes,
and
I'm
about
getting to that, but
Okay, great. Thank you.
this is also important stuff. I've included a model policy that's available from another national organization that's based on police policies from various locations around the country. I also did an analysis of the most recent 30 cases of use of force. And I want to say a couple of things about that. One is that about half of those, a little more than half, were instances where people said, you know, I want to commit suicide or kill me, or there were suicidal tendencies. That's important in terms of the reports. Also, a little more than half were instances where people were killed and a little less not killed, but wounded. And in 2 or 3 cases, shots were fired, but nobody was hurt in the process. All of these were gun related. And I want to emphasize that I think the reports need to change in addition to the fact that they should be expedited for a couple of reasons. One, I think that a report, which I did not see in any of the reports, need to identify the particular use of force policy of the local law enforcement agency that was consistent with their use. And second of all, I think there needs to be an analysis of how the reports are written so that there is some looking at what was done well, what was not done well. Because if we don't use those reports to learn from those experiences, then we keep making the same mistakes over and over again. As mentioned, a number of those instances were, in addition to suicidal, there are mental health related issues. There are concerns that need to, you know, they were mentioned in most cases in the reports, but not focused on and not analyzed in any way. So in addition to the reports being expedited, I think they need to be analyzed by either, well, actually probably both the Attorney General and the Deadly Force Review Panel.
Thank you very much, Mr. Danziger. Committee members, are there any questions for Mr. Danziger that focus on aspects of 1480 that you'd like to ask? Not seeing any. Thank you for being here, and sorry I missed you on the initial round of proponents. And is there anyone in the attendee space who is here to testify neither for nor against LD 1480? Not seeing any hands raised, and so with that, we'll bring the public hearing on LD 1480 to a close and begin our next public hearing. The next public hearing is on LD 1676. This is an act to limit access to juvenile records and protect the confidentiality of juvenile history record information. This is a bill that's going to be introduced by our committee member, Aaron Sheehan, Representative Sheehan, and then a number of the people who have been working so hard on this legislation over the last year and a half will provide additional information. And so with that, Representative Sheehan, we are pleased to hear from you on this bill.
Thank you, Madam Chair. Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Erin Sheehan, and I represent Biddeford's House District 12. Unfortunately, the bill sponsor, Representative Rachel Talbot Ross, cannot attend today's public hearing due to a death in her family. So I'm presenting LD 1676, an act to limit access to juvenile case records and protect the confidentiality of juvenile history record information. LD 1676 is the product of a great deal of hard work over the past several years by a group of stakeholders. It's been a truly incredible effort, and Representative Talbot Ross is so very grateful for their dedication and expertise. You'll hear from a number of them today. Cumberland County Assistant District Attorney Christine Tebow is here today to speak to the details of the proposal and to the careful consideration that has gone into its drafting. Representative Talbot Ross would like to thank her in particular, as well as the chairs, for accommodating her unexpected absence. Representative Talbot Ross looks forward to joining us for the work session, and please feel welcome to contact her in the meantime with any questions or requests for information. Thank you.
Thank you so much, Representative Sheehan. Go ahead, Representative Harnett.
Thank you, Madam Chair. Same question as I had on the first bill regarding the timing of Ms. Tebow, as she is in essence presenting the bill for the bill sponsor. I just want to know how to proceed in terms of timing.
Committee member and members, in light of the fact that the sponsor has been not been able to join us because of a death in her family, is it okay with committee members that we give Ms. Tebow additional time? Lots of nodding heads. Thank you, everyone. Thank you for raising that, Representative Harnett. With that, I'll bring Ms. Tebow over to the panel. Welcome, Ms. Tebow.
Good morning.
Welcome to the Judiciary Committee, and thanks in advance for all your hard work on this bill. You can go ahead.
Thank you very much. Senator Carney, Representative Harnett, honorable members of the Judiciary Committee. My name is Christine Tebow. I'm an Assistant District Attorney in Cumberland County, where I specialize in juvenile prosecution. However, I'm testifying this morning in my individual capacity as one of the individuals who's worked with Rachel Talbot Ross and with your committee analyst, Peggy Ranch, for a long time to bring these proposals to you. We recognize that the bill is long and it's dense, and I hope you'll be relieved to know that much of the language that exists in the bill is in current law. It's just being relocated to a new area. Also, several of the provisions are simply technical changes to either clarify definitions or to correct cross-references. My written testimony contains a section by section breakdown, which I hope will make it easier for you to look at a glance and see, oh, this section just corrects a cross-reference, and then you can disregard that. My testimony this morning, however, is going to focus on the general substantive changes, and they are large, that are being made in this bill. To start with, I'd like to orient you on the theme of this bill. This bill is about who has access to juvenile records, juvenile justice related records, who has the ability to be present in juvenile court proceedings, and what happens when confidential information related to juvenile justice is shared unlawfully. There are some key terms that I'm going to use that I want to just introduce at the outset. The first, and you're going to hear these repeatedly, the first is administration of juvenile justice. There are several provisions of this bill that create a uniform definition of administration of juvenile justice. Current law contains conflicting and inconsistent definitions of administration of juvenile justice and administration of juvenile criminal justice. And one of the principles of this bill is to clarify that we're talking about one thing, and that's administration of juvenile justice. And we're proposing eliminating the term administration of juvenile criminal justice because frankly, that term is an oxymoron. It's either juvenile justice or it's criminal justice, but the two processes are very distinct and they should be recognized as such. The next term that you're going to see in the bill is juvenile history record information. Currently, Maine's Criminal History Record Information Act, that's Title 16, Chapter 7, does not apply to juvenile justice related information. There is no law that governs the collection or dissemination of juvenile history record information. And this bill proposes a definition and some guidelines, some statutes regarding the dissemination of juvenile history record information. And it locates that provision in the juvenile code, not in Title 16, but in the main juvenile code where people can find it more easily. Juvenile history record information is essentially information collected by and maintained by criminal justice agencies regarding an individual juvenile's involvement in the juvenile justice system. An example would be a record of whether an individual has been adjudicated of a juvenile crime. Section 9 proposes creating an analogous system of maintaining and disseminating those records based on whether they are confidential or public. And frankly, they're mostly confidential. The only juvenile history record information that would be public by statute would be a record of an individual's adjudication for a felony level offense, a class A, B, or C crime, or murder. All other juvenile history record information would maintain confidentiality and would be subject to limited dissemination as allowed by law. The next term that is frequently used is juvenile intelligence and investigative record information. And this is also collected and maintained by criminal justice agencies, but it's more of investigation and intelligence that's maintained by police departments. So think about police reports or an individual juvenile's contacts with police. Currently, the main juvenile code defines and creates confidentiality for Juvenile Intelligence and Investigative Record Information Act. Section 15 of this bill makes one relatively small change to existing law by allowing confidential juvenile investigative and intelligence information to be shared with government agencies that are responsible for investigating child abuse, neglect, or exploitation, or licensing daycares. It's an important change, but it doesn't really make a substantive principle change in the juvenile code. The heart of this bill is around juvenile case records. Juvenile case records are all information that is received by, generated by, or maintained by the juvenile court. The juvenile code currently defines juvenile case records. There are two types of juvenile case records that are extremely important to understand. One is the petition, that's the charging document that's filed with the court, and the other is an order of adjudication. Those are the two juvenile case records that the public has the authority to inspect. And when we say inspect, we don't mean to receive a copy. The language we're trying to put forth is very clear that the public's ability to inspect a record means just that. They can view it, but they cannot obtain an electronic or paper copy of the records. Current law allows the public to inspect a petition or order of adjudication when a juvenile is charged with a felony or murder or a second or subsequent Class D juvenile crime. I'm going to come back to that in a second. The big change in this bill is that it creates a tiered system of allowing public access to juvenile case records. And it all hinges on whether the petition is open to public inspection or not. All juvenile petitions will start as confidential. Current law allows a juvenile petition to be inspected immediately after it's filed in the court. There's no wait period. We are proposing a 30-day wait period before, actually 30 days after the juvenile's first appearance, before any petition is allowed to be inspected by the public. No petition may be inspected unless a juvenile court judge finds probable cause to believe that the juvenile has committed a juvenile crime. Current law does not require that. No juvenile petition will be open to inspection if the proceedings are suspended to determine whether the juvenile is competent to proceed. So that is basic protection for all juvenile petitions. Now, assuming that we've had a first appearance in court and 30 days has passed, the court has found probable cause, and there's no challenge to the juvenile's competence, there will essentially be that the petitions will fall into one of four categories. First is the category that would be open to the public and may not be made confidential. These petitions include those that allege a juvenile 13 or older commits murder, felony murder, or manslaughter. Second category petition is open to public inspection, but may be made confidential by court order. This category includes petitions alleging a juvenile 13 and older is charged with a Class A crime. And the proposal includes a process for petitioning the court to have those presumptively open petitions made confidential. The third category of petitions are those that are confidential, but may, upon request and court order, be made open to public inspection. And this category includes petitions alleging a juvenile under 13 who's committed murder or a Class A crime, or a juvenile of any age committing a Class B or C crime. So any felony level crime committed by a juvenile or particularly serious crime committed by a very young juvenile starts as confidential, but a judge may allow public inspection. Again, there's a process defined in this proposal. And the fourth category of petition is those that are confidential and may not be made open to public inspection. And that category includes petitions for a juvenile of any age that allege Class D or E crimes, or what would be a civil violation if committed by an adult. The proposal includes some special provisions to allow victims to access juvenile case records and to be present in juvenile court proceedings most of the time, even though the public may not be allowed access to those materials. The one exception is when a juvenile is challenging competence. That shuts down the process, and the victims may inspect the final order, but may not be present for that competence proceeding. And you may hear from some of my colleagues who will explain that in greater detail. Another less significant but still important proposal that changes existing law is that around sealing of juvenile case records. This proposal does not change the process as it exists for sealing petitions that allege murder or Class A, B, or C crime, but it does introduce an automatic sealing provision for juvenile case records when a Class D or E crime or a civil violation has been adjudicated. And that sealing becomes automatic upon the court receiving notice that the juvenile has completed their disposition. And that notice may come from either the Department of Corrections, if the juvenile's on probation or committed to Long Creek. It may come from the prosecutor if a juvenile is ordered to pay restitution through our office or complete a restorative justice event. Or it may, the juvenile, him or herself, may file a notice with the court. The proposal offers two mechanisms for enforcement. We've created this, what we believe to be very fairly balanced, somewhat complicated process for determining confidentiality of juvenile records. And without an enforcement record, those laws are hollow. So this bill does present two mechanisms for enforcement of these laws by allowing a civil violation to be filed against any person who knowingly and intentionally disseminates confidential juvenile records or information. And that would be subject to a fine of up to $1,000. So that's against the person who is disseminating the materials. The other enforcement mechanism is creation of a civil cause of action that may be brought by a juvenile aggrieved, aggrieved by the dissemination of that information, and it allows that aggrieved person to seek injunctive relief, excuse me, court costs, attorney's fees, actual damage, and punitive damage. These enforcement mechanisms are offered as a way to recognize and hopefully deter broad-scale dissemination, data mining, and quite frankly, exploitation of juveniles who've been through the juvenile justice system. We've worked very hard to, when I say we, I'm talking about prosecutors, defense attorneys, folks from various state agencies, and local juvenile justice experts, to put forth a proposal that is fair, balanced. It acknowledges juveniles' right to privacy, but it also acknowledges the public's right to have information when a juvenile is alleged to have committed a very serious crime. And it acknowledges that the public has an interest in transparency of juvenile court proceedings. I welcome any questions you have, and I appreciate your time this morning. Thank you for the extra time. And I'll take any questions.
Thank you so much, Ms. Tebow. That was a very thorough explanation of an incredibly complicated piece of legislation. I just want to start with, we've got a couple of hands up, but could you just quickly outline the team that has been working on this? I know that they'll go ahead.
Yes, so for prosecutors, myself and Tanya Pearson, who is an assistant district attorney in York County, who has been, like myself, in the juvenile court system for decades. Attorney Ned Chester, who has been a juvenile defense attorney for decades. Professor Chris Northrup at the University of Maine School of Law. Jill Ward, who is a national expert who we're fortunate to have here in Maine, who is the director of the Maine Center for Juvenile Policy and Law. We've consulted with Chris Parr from the Department of Public Safety. We've consulted with attorneys for the Department of Corrections. I'm sure I'm forgetting others along the way, but there have been a lot of folks, a lot of fingers in the pie, so to speak.
Thank you very much for answering that question. It's a very broad and impressive group. And I see that we have some questions. We'll start with Co-Chair Harnett. Go ahead.
Thank you, Madam Chair. Nice to see you again, ADA Tebow. And I also want to thank you for the enormous amount of work that's gone into this. It's spanned a couple of years now. And I have what I think is a simple question, and if you touched on it, I apologize. You talked about the process that allows, in certain instances, someone to inspect records, but not to have those records produced to them. In those cases, are they then allowed to disseminate that information? I mean, they can take notes, they can learn information, or are there instances in which they are allowed to inspect what is actually confidential records and that they are not allowed to disseminate them? Does the question make sense?
Yes. So if you think of it this way, if the records are confidential, they may be, the court may authorize limited dissemination, and there may be a court order. In fact, one of the proposals would require the court, if it makes a decision that confidential juvenile information may be shared, the court must specify to whom that information may be given and the scope of the dissemination. So for example, if I'm the parent of a victim, of a child victim who's been a victim of a juvenile crime, I may want to see the petition, even though it may not be open to the public, but the court may say, okay, Ms. Tebow, you can view this, but you may not share this information further. Conversely, if it's something that's open to the public, like a petition for against a juvenile alleging murder, and there's no confidentiality to begin with, and that would be open to the public, and there wouldn't be a confidential juvenile record to protect. Does that make sense?
It does. Thank you very much.
Thank you both. Representative Moriarty, you can go ahead with your question.
Great. Thank you, Madam Chair. Good morning, Assistant DA Tebow. I'm wondering whether the stakeholder group that you just described originally came together by virtue of legislative resolve or some other mechanism.
some other mechanism. We have been, when I say, many of us work together very closely in Cumberland and York County. And so we have these conversations, and they've been going on, frankly, for years, of some of the problems that we encounter on a daily basis. We say, gee, we need to fix this. And one of the things that we've recognized in the last decade especially is that the internet and social media, both of which are favorite tools of juveniles, have created some problems in terms of how the information that we have access to has been misused or exploited. And so several of us came together and began thinking of fair ways to change, radically change who has access to juvenile case records. But we predated the Juvenile Justice Task Force, if that's what you're thinking. We're independent, although many of us, well, all of us are on that task force, we actually been doing this longer.
And as a quick follow-up, for attorneys who represent indigent defendants and juveniles included?
Yes, Ned Chester. He,
Ned,
the Bureau
yes.
of Juvenile Justice, yes.
Okay, thank you.
Senator Keim, go ahead.
Thank you. Really nice to see you, Ms. Tebow. Thank you for all the work that you've done. I really appreciate your involvement. I know it's so valuable to the state of Maine, all the work that you do in so many ways. So a couple of questions. One is, in the working group, there wasn't anyone there that seemed to be on the side of the public's right to know. So that's my first question. How do you think your work balances that? In this bill, I should say.
Yes, we did have that concern, and that was definitely part of our conversations. And I guess perhaps the prosecutors, myself and ADA Pearson, were the two that were most sensitive to that concern. Recognize that indeed there is a public's right to know when a juvenile is accused of a very serious crime that affects their community. In the last legislative session regarding 1964, we did consult with some of the press. Some members of the press had some legitimate concerns about transparency of the juvenile court process and the community's right to be aware of serious crimes that are committed by juveniles. So we did incorporate that, and I think that's why we tried to create a tiered system that allows some judicial discretion, recognizing that it's impossible to predict which cases are going to be important to public's right to know. So for example, you may have a juvenile that's accused of committing a string of residential burglaries, which would be a Class B. And you may have a neighborhood or a city that's up in arms about that. That petition would start as confidential, but any person, whether it's the press or myself or a community organization, could petition the court and say, we want to know about this. And the court has the discretion to authorize that public inspection. If a petition is open to the public's inspection, then the public is may be present at the court proceedings. So that's kind of the key, that opening of the petition opens the door to the courtroom as well. And we purposely crafted a system that allows a lot of judicial discretion because frankly, these are very case-by-case situations. We may have a juvenile that commits a very serious crime, but is maybe 14 or 15 chronologically, but developmentally 8 or 9 years old because they're on the autism spectrum or whatever. And we want to have we want to give the court discretion to say, okay, that case is presumptively open to public inspection, but in this circumstance, I'm going to order it to be confidentiality in light of the special circumstances that the juvenile presents. So we addressed that, I think. The bottom line is we addressed it by giving the court a lot of discretion.
Thank you for that. That's helpful. And the second question I have is, I always try to balance how, we want to allow people second chances with the fact that sealing of records is basically saying, go ahead and lie about your past. And that's really tough for me. And especially to say it to a juvenile, who's still formative, for the state to say, this is permission to lie. Give me your thoughts on that, if you would, please.
Yes, so for the reason you've just stated, we prosecutors frequently dismiss or reduce juvenile crimes. I think most prosecutors are sensitive to the consequences that come with an adjudication, even for a juvenile crime. And that is why it's very common for us to dismiss charges so that the juvenile doesn't have to lie. They can say, no, I haven't been adjudicated of a juvenile crime. There are cases, however, that are more serious where the state may believe that that adjudication needs to be on a person's record. Let's say they have a history of gross sexual assault against small children in an aggressive manner. We want that record to be available to the public. So we have made no changes to the petitions that allege serious crimes, class A, B, and C, and murder, if committed by a juvenile. That's still subject to existing law, waiting 3 years, and the judge has to order the record sealed after a hearing. With regard to the misdemeanor level crimes, class Ds and Es, there seems to be less of a public's need to know, frankly, and I understand that discomfort with juveniles lying about their record. I don't know that I have a good answer for how to resolve that, but I think from a policy perspective on fairness, at some point it becomes a burden. And I think especially given the technology we have today and the ease with which people can find information, some of those adjudications, they're not open to the public inspection anyway. If a person, a prospective employer were to run a background check, for example, they would not see a juvenile's adjudications for class D or E crimes or civil violations. So the juvenile saying, I have never been adjudicated is a moral issue, but it's less of a legal issue, I guess, for me. It's a very unsatisfactory answer, I know. I'm sorry.
Thank you. I appreciate you walking through it with me.
Thank you, Senator Kime. Representative Thorne, go ahead with your question.
Thank you, Madam Chair. And thank you, Assistant District Attorney Tebow. I asked this question. I haven't paid attention as closely as I should have, so if you've already answered it, I apologize. But having been a former Air Force recruiter and a former Air Force flight chief for the state of Maine, how would this affect military being able to obtain records on juvenile law violations?
Well, thank you for that question. No, it hasn't been raised yet, but it did come up in last session's 1964 work session. And that was a point of split among the committee members. The original proposal did include language that would allow military access to confidential juvenile history record information. That provision was stripped from the bill this year. Because it was opposed in the bill last year. We did not reintroduce it in this session. We had some discussion about that. We recognize that that's an important need. That said, my experience, and I think others' experience, is that military recruiters get what they need through the juvenile. And the juvenile, everything that's confidential can of course be given to that juvenile. And he or she can then be required to turn it over to the military. The one flaw, I guess, is that it doesn't allow the juvenile to be deceptive. So if a juvenile were to apply to enlist in any branch of the military and say, no, I've never been involved in the juvenile justice system, I've had no police contact, and that's a bold-faced lie, the current law would not allow that lie to be disclosed. So yes, that is, it's been a point of discussion.
If I may ask a follow-up question, Madam Chair,
Yes, go ahead.
and you may not know the answer to this, Assistant District Attorney Tebow, but at what point would that come to light in the process? Are you familiar with that at all? Have you experienced that? In other words,
You know,
yeah.
I don't. I've worked with many recruiters, and usually they come in and with a signed release, and I will say the signed release doesn't help me get past the law, but I will provide the prospective enlistee with everything that you're requesting, and he or she can give it to you. So the cases that I've seen all have been with the release, so the recruiter knows that there's been some involvement. If somebody were to completely be deceptive and lie about that, I don't know where that would come to light, but I'm sure it would have severe consequences at the military level if that person were found to have lied on their application.
Right, and I just try to avoid being down in basic training and the whole process, and you know, at a certain point, and then having that come to light if we could. So interesting. Thank you for that. Thank you, Madam Chair.
Committee members, are there additional questions for Ms. Tebow? For ADA Tebow? Representative Harnett, is your hand up for timing purposes?
It is, Madam Co-Chair. I was frozen out, had to get back on, so I raised it again.
Thank you so much. Appreciate it. I am not seeing any additional questions. Ms. ADA Tebow, who should I call second? I know you have a whole team lined up here.
I would invite Attorney Ned Chester and then perhaps Ms. Ward.
Okay, I'm going to keep you on the panel if that's okay with you.
Sure.
And we'll begin with bringing Attorney Chester over. And Mr. Chester, you can go ahead and activate your audio and video whenever you're ready.
My apologies.
Thank you so much for joining us. And on behalf of the entire committee, thanks for all your work on this legislation.
I always strive to be as technically competent as a 10-year-old. That's kind of my standard. I fail often. Senator Carney, Representative Harnett, and members of the Committee on the Judiciary, my name is Ned Chester. I'm an attorney in Portland, and for about the last 30 years, I have focused my practice on representing juvenile defendants. I appear today before you to speak in support of LD 1676. My task is to address those provisions of the bill that address confidentiality of the case records that are generated by the competency process. I have filed a much longer written testimony that goes into the basics of what the competency process is and why it exists. But let me just say that the purpose of a competency hearing is to determine if a defendant should even be in court. And settled law is that if a defendant, whether juvenile or adult, is not competent to proceed, that proceeding must be dismissed. Maine has a very progressive juvenile competency statute, and I will say that many of the people who are here today and testifying in support of this bill were part of a group of people who put together that bill and submitted it on a bipartisan basis, if you will, back in 2011. We have come to realize now, however, that as good as that original statute is, it does not address the issue of confidentiality in a competency hearing. That issue came to a head recently in two of my cases involving juveniles who are severely disabled and whose cases were dismissed after a competency hearing. In one case, the victim in that case wanted to obtain court records in order to support a civil suit against the juvenile and their family. In the other case, the victim wanted to sit in on the competency hearing, and again, I suspect it was to support gathering information for a later civil suit. Both defendants challenged the requests, and District Court Judge Darvin issued rulings in both cases denying the victim's requests and upholding the confidentiality of competency hearings. There are many reasons to shield the information generated in a competency hearing, but first and foremost, it is because that information that is revealed in a competency process is intensely personal to the juvenile and their family. It necessarily includes detailed information about the juveniles and often collaterally the family members' cognitive, emotional, mental health, and behavioral issues. The release of that information would be contrary to the purpose of the code, regardless of the outcome of the hearing, and would be particularly troubling after a public hearing exposed all of that sensitive information if the juvenile was found not to be competent. Madam Chair, could I have just one more minute?
Yes, go ahead.
Thank you. My clients were both facing significant uphill battles to live a somewhat normal life because of their disabilities, and particularly in this era when information spreads rapidly and can be used as a weapon, it was important to protect their privacy. Again, particularly because it was determined that they should not have been in juvenile court in the first place. And that's not to suggest that the district attorney did anything wrong, but they shouldn't have been there in the first place, and to have all of that sensitive material available to the public would be a gross injustice. The provisions of 1676 that apply to the competency hearing are essentially adopt Judge Darvin's rulings. Section 21 makes it clear that juvenile case records generated by the competency process, including the petition, the reports of the experts, and the transcripts of the hearing, are not subject to inspection, dissemination, or release by the court. Section 22 makes it clear that the competency proceedings are open only to court-related personnel, the juvenile community corrections officer, the parents of the juvenile, and witnesses. And Section 23 is consistent with Judge Darvin's intent to allow the victim to see the court's actual final orders on the issue of competency and whether to refer the case to the Department of Health and Human Services for review of services available to the juvenile. These provisions in 1676 provide necessary protection for some of our most disabled juveniles and families. They reflect good policy and a balanced approach to the rights of the juvenile and the rights of victims. They're consistent with the other provisions of LD 1676 and the code, and they are supported by at least one judicial decision. I respectfully urge you to support and pass LD 1676. Thank you.
Thank you very much, Attorney Chester. Excuse me, committee members, are there questions for Attorney Chester? I think you covered the material really well. Thank you so much for being here. And without any more questions, I'll return you back to the attendee portion. And then ADA Tebow, who would you suggest next?
Jill Ward, please.
Thank you. Ms. Ward, welcome to the Judiciary Committee. And again, on behalf of all members of the committee, thanks for all your hard work on LD 1480.
Thank you.
1676.
Thank you, Senator Carney and Representative Harnett and distinguished members of the Judiciary Committee. My name is Jill Ward and I live in South Portland, and I currently manage the Maine Center for Juvenile Policy and Law at Maine Law. And I'm submitting testimony on behalf of the work group that has been described to you to date and is documented in the written testimony that I submitted earlier this morning. We established a practitioner work group in about, I think, 2015 around a variety of issues that we, as ADA Tebow has described, that were common issues, policy problems that were coming up again and again, to try to do collaborative problem solving with practitioners and policy experts to come to consensus resolutions on issues. And so this work group, one of the first things that we did together was back in 2016, we worked with the University of Maine's Muskie School to develop what is the sort of seminal research report in this area, the Unsealed Fate Report, the Unintentional Consequences of Inadequate Safeguarding of Records in Maine, which documented widespread misunderstanding and confusion around juvenile records law and documented collateral consequences for young people whose confidential juvenile information is unintentionally shared and or with respect to having an adjudicated record. So we served as an advisory board on that report, and that report was released in 2017, and it had numerous recommendations around practitioner education, public education, and changes around administrative and statutory law with respect to juvenile records. And so this proposal is a result of that and is a continuation of legislation that this body approved last session and is current law around making the juvenile code clear and streamlined for purposes of public understanding, but also to align the code with the judicial branch's move to digitize records. So we were really trying to balance, practically speaking, how juvenile records were handled and also embody some of the policy changes that we saw come out of the research report that needed to be addressed. So you've gotten a lot of detail here, and I'd just like to say, not to lose sight of the fact that one of the most important things that this bill does is prohibits public online access to juvenile records. You have heard the rubric that we have come up with to balance the ability of the public to inspect certain records under certain circumstances. But generally speaking, it is good policy and practice and consistent with all of the other New England states and most states to not allow this information to be publicly accessible online for many of the reasons that you've heard today. The second thing that it does is it does automatically seal low-level offenses to help juveniles be able to move forward consistent with the juvenile code and the notion that we do want to legitimately have young people have second chances to be able to not have their juvenile record be a barrier to employment or housing or secondary education. So I apologize for rushing through. I see my time is up, but I am certainly available for questions, the work session, and I would also draw your attention to my testimony has attached to it a letter of support from Maine organizations, child advocacy, other organizations that are very supportive of this proposal. Thank you.
Thank you very much. Committee members, are there any questions? Not seeing any from the committee, but I had a question for you because this was an area that I actually wasn't particularly familiar with, but can you speak to us a little bit more about the policy reasons underlying automatically sealing low-level offenses, like what the goals are of the Maine's juvenile justice system and how that particular provision carries out those goals?
Yeah, the research report in Unsealed Fate found numerous documentation of barriers for young people who had a record, and it came up in a couple of different ways. The way that the background check is conducted, if an employer goes to look for a record, the record comes up, there's like what in sort of common parlance, there's a ping, and so the employer just says, oh, they have a record. They don't know if it's an adult criminal record. They don't know if it's a juvenile record, and then they don't get the job. Young people who talked about applying for public housing, who would again have this background check ping something up for them, and it would prohibit them getting that housing. You put that together with the fact that most juveniles, and it was like a high percentage rate, juveniles, even stakeholders, defense attorneys, prosecutors, thought that a juvenile record was sealed in effect at age 18. So you also had a circumstance of you had this consequence happening, and you had young people that didn't even understand it because they had an assumption through the prevalence of misinformation that their record was automatically sealed when they turned 18. So they went out into the world and didn't think it was a barrier, but was turning up to be a barrier. So by, especially with low-level offenses, as ADA Tebow has talked about, to remove that barrier and to really allow the adjudication, you know, the terms of their adjudication to be done, and to not put on them the burden of having to petition the court 3 years later to know that that is what the law is, potentially have to get counsel that costs money to help them petition the court. This is very consistent with what other jurisdictions are doing and recognizing we really need to eliminate those barriers to let those young people have access to the opportunities that they need to have to get their lives back on track again. And I would say that I can document what's going on in other states for this committee if you're interested for the work session, but this is very common. Lots of states are automatically sealing or expunging low-level offenses, arrest tracking data, any of those sort of more less serious sort of transgressions to make sure that they don't become permanent barriers and follow the young person.
Thank you. That was a great, thorough explanation. Appreciate that. Representative Babbage, did you have a question?
Thank you, Madam Chair. A quick one, I hope, but I think Ms. Ward might be the right person to ask. As we're looking at this issue and the whole idea of juvenile justice related to this bill, you know, I'm looking at age as a, I mean, is juvenile justice absolute, or can it be incremental by age? We have designated 13 in the bill as a dividing line. I wondered if, in looking at the protection of society, which is the opposite, you know, perspective here, because I do believe in second chances. I supported this bill last time. I'm sure I will support this one. But I want to ask for an offense that is perpetrated the day before a person turns an adult. Do you know if that is in any state treated differently than one that is done when they're 13 or 14, as far as the protection of society through access to the record by, I don't know, the military as brought up, or the press, or whatever? Do you understand my question?
Well, I think let me try. The age of 13 in the current bill is just respect to competency. It is not a sort of an absolute jurisdictional age. It is the analysis is triggered, and some of that is because developmentally 12, 13, 14 is sort of, according to research and adolescent development and sort of where policy is moving in this area, is where you have issues, more frequently issues of competency. You have more of those adolescent development factors playing into the behavior of a young person. So this bill doesn't sort of absolutely say if you're under 13, but it does use 13 as the trigger for the different mechanisms that ADA Tebow has described based on the offense and what is required, or, you know, who can petition the court to either move away from an assumption of confidentiality or an assumption of public access. Does that help?
It addresses that. I wondered if there was a separate standard that you're aware of across the country for, say, 16 and 17-year-olds.
When it comes to what exactly? I mean, juvenile court jurisdiction over time has been, so, I mean, if you really want to sort of, the context is in the early 90s, there was a big move towards adultification of young people's behavior, more things, you know, more young people were being tried as adults. There was a whole sort of criminal justice theory around super predators that did not play out, and states moved in that direction. Now you're seeing, and I think there are only 2 or 3 states left that have moved the age predominantly, with some exceptions for serious offenses, of juvenile court jurisdiction back up to 18. Some states still have 16 and 17 for serious offenses, but generally speaking, and this trend has been documented, states are moving to 18, and in some cases starting to look at 20 and 21 as an upper age of juvenile court jurisdiction, based on the adolescent development research, based on this idea of emerging young people, that 18 is in some senses a very arbitrary number that has been picked over time based on other types of statutes that have been put in place around other types of behaviors like smoking and voting and, you know, entering the military. So I think that's what you're seeing nationally trend-wise, if that's helpful.
Thank you for that. That is helpful. Thank you, Madam Chair.
Sure.
Not seeing any additional questions for Ms. Ward. Thank you again for being here and for answering our questions this morning and for your work on this legislation. I'm going to move you back to the attendee space. ADA Tebow, who should I bring over next?
I believe Professor Chris Northrup is going to offer some testimony.
Thanks. And then who would I bring over after him? Because I can do that now as well.
ADA Tanya Pearson.
Thank you.
Good morning, Senator Carney, Representative Harnett, honorable members of the Judiciary Committee. I'm Chris Northrup. I'm a proud resident of Sanford, and I am the director of the Juvenile Justice Clinic at the University of Maine School of Law. And I'm going to use my time to, I think, pick up on the conversation that Senator Carney and Jill were having around the issue of sealing and hopefully go a little bit deeper. I'd like to talk about this. One is because this is where it all started for me, and this goes back to Unsealed Fate. When we were doing the research for Unsealed Fate, we found a lot of surprising things. And the surprising thing to us was that the widespread misunderstanding around terms like sealing and confidential and disclosure were not just limited to the youth who were system involved, but was prevalent among many of the professionals working in the juvenile courts. Judges, defenders, JCCOs, we all had this wrong. And when the report came out, the clinic decided to take this piece on as a project. We worked with a large coalition to put a trifold pamphlet together around consequences of juvenile adjudications. We got that out to every district court in the state. It offered free legal advice from the clinic for anyone who had questions about it, but also representation for folks who were looking to seal their juvenile records. We had a lot of people contact us, and we probably had 10 or 12 sealing cases come from that. And the youth that we represented aren't going to be affected by the proposed statutory change. They were youth with significant adjudications that gave them obvious consequences in their life. The big change, as Jill detailed, is the automatic sealing of low-level juvenile adjudications. And these are done automatically as soon as a juvenile is through with the system. As soon as they are discharged from delinquency, there is an automatic sealing, and it is, I think, analogous to expungement in that it does take it off the record. They don't have to disclose it because that's important. It truly makes a confidential case. Currently, even though misdemeanor offenses are not open to the public, they still hold youth back from employment, from education, from housing. On most applications for all those things, there's a question, and they ask for youth and emerging adults to disclose juvenile adjudications. Suddenly, that shoplifting, that fight at school, that possession of a scheduled drug becomes a really significant barrier for things that are important for emerging adults. This proposed legislation assures that youthful indiscretions stay just that, youthful indiscretions, and not a burden youth bear as they transition to adulthood. I urge you to support LD 1676. Thank you for your time this morning.
Thank you very much, Professor Northrup. Committee members, are there questions for Professor Northrup? Not seeing any. We really appreciate you being here today. And once again, thank you for all of your great work on this legislation.
Thank you.
And Ms. Pearson, welcome. I wanted to, of course, welcome you to the committee and also thank you as well for your work. And you can proceed when you're ready.
Thank you. Good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Tanya Pearson. I live in York, and I am an assistant district attorney for York County. I'm also here in my capacity as a juvenile assistant district attorney, but I'm not here representing the Maine Prosecutors Association. The Maine Prosecutors Association has not been able to weigh in on the legislation yet. Hopefully by the work group session, the MPA will have the opportunity to take a position. I am extremely proud of the fact that I've been working in Maine in juvenile justice for over 20 years. I am particularly proud of how the state of Maine handles juvenile cases in the criminal justice system and all the dedicated players who are involved in the process. Our work group, which has been referenced throughout, is a perfect example of that collaboration. Gratefully, the committee allowed ADA Tebow to talk further and give her additional time. She already talked with you briefly about the civil penalty provisions, which I was going to talk about. So I'll just comment on those myself briefly and give the committee an example from my experience as an ADA. Important to recognize that the burden of proof for bringing an action is knowingly or intentionally. This is a very high burden. In this proposal, we are not trying to penalize anyone who mistakenly releases confidential information. This is intended for willful violations, which can have significant consequences for a juvenile, as the committee has heard. The importance of creating this provision is to discourage unscrupulous individuals or media outlets from disseminating often highly inflammatory confidential information. And as you've already heard, once the information is out in the universe, it is virtually, no pun intended, or maybe a pun intended, it's virtually impossible to retract it. The district court has sole jurisdiction over any action filed under either of these penalty provisions. One of the best examples I can give you of the importance of discouraging the release of extremely sensitive information and the need to carefully guard a juvenile's confidentiality was a very high-profile juvenile case in York County. It was the Sanford Mill fire. It was a massive fire. It received a ton of press. 3 juveniles were charged out of the incident. At the time, they were 12 and 13 years old. It was clear from the evidence that the juveniles never intended for the fire to occur. Due to their young age, gratefully, the press respected the juveniles' confidentiality and never revealed their names, but they could have under the current statute. Furthermore, even though the press did not release their names, public press forums and social media outlets were swiftly inundated with commentary. Because of that publicity surrounding the case, the juveniles were unable to remain in the Sanford community or to return to their schools where they had been enrolled, as word spread quickly within the town regarding who was involved. They were ostracized by many and labeled as dangerous criminals. Remember, they were 12 and 13 years old at the time, and clearly from the facts of the case, they had no ability to anticipate the risks of their behavior. Ultimately, all 3 children were placed in new living situations and services were wrapped around the youth. They were able to reestablish their lives in different locations without a ton of the notoriety following them. I am thrilled to report to everybody that all 3 are doing extremely well, and it's a success story and exactly how the system, the juvenile system, is supposed to function.
Ms. Pearson, I'm going to ask you to stop there.
Yes.
And let's see if there are committee questions. And first of all, thank you. That was a real life example is really helpful. It kind of makes the importance of the law stand out in a different way. And I see that there are a couple of questions. Representative Moriarty, go ahead.
See, Madam Chair, I have a question for you, but I'll defer to anybody else who has a question for the witness.
Does anybody have a question for ADA Pearson? Not seeing any. All right, go ahead, Representative Moriarty.
Okay. First of all, if Chair Harnett wants a break, I'll volunteer to do the timekeeping for the rest of the session.
I think he's okay.
Okay. Secondly, I couldn't find any information on this bill on the committee's webpage. So I don't know if anybody's registered or signed up to testify in opposition.
I can look into that while the next person is, looks like Representative Harnett has that information.
There is one person testifying in opposition, registered to testify in opposition, which is Judith Meyer from the Maine Press Association. And there are two people that are testifying neither for nor against, Julia Finn and Catherine McBrien.
Okay, all right, thanks. It's useful to know that. Thank you.
Okay, so any additional questions for the ADA Pearson? No, I think not. Once again, thank you for providing testimony today. And ADA Tebow, who would I bring onto the panel next?
The only other work group member who may be in your waiting room is Attorney Chris Parr from the Maine Department of Public Safety. I'm not sure if he was going to be able to make it today or not.
He is here, and I'm going to bring him over.
That will be, I think, the last member of our group.
Thank you.
Hey, good morning.
And thank you as well for your work on this important legislation. Go ahead.
It was my great honor to be a consultant for the group. Just a wonderful group of people, and they worked very hard on this. So, good morning, Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. My name is Chris Parr, and I'm here today to testify on behalf of the Maine Department of Public Safety in support of LD 1676. This important bill is a culmination of an approximately 2-year collaborative effort between juvenile prosecutors, juvenile defense attorneys, and representatives of the University of Maine Law School to address numerous issues not currently addressed in the Maine Juvenile Code, as well as to strengthen protections of juvenile crime-related records and information. Significantly, the bill addresses the general treatment of criminal history record information that relates to juveniles. Such information is termed juvenile history record information in the bill, which current law does not address but needs to. The bill also provides for the automatic sealing of juvenile case records for crimes that, if the juvenile were an adult, would constitute Class D crimes other than operating under the influence, or Class E crimes, upon the completion of the disposition ordered by the juvenile court. By so doing, LD 1676's enactment into law will ensure that juveniles who commit such crimes do not need to take future action and incur future costs to independently seal such records. In addition, the bill strengthens the protections in law of juvenile court case records and juvenile intelligence and investigative record information. Those protections are further strengthened by the bill's creation of civil violations and a private cause of action to address instances in which confidential juvenile court records, confidential juvenile CHRI, and confidential intelligence investigative records related to juvenile crimes are knowingly or intentionally disclosed publicly in violation of a law or court order. For those reasons, the Department of Public Safety very much encourages the committee to move and endorse an auto-pass report for LD 1676. Thank you. I'd be happy to try to answer any questions that you might have.
Many thanks, Mr. Parr. Committee members, are there any questions? I am not seeing any questions for you, sir. Thank you for being here today and also for your work on this bill.
Thank you.
And ADA Tebow, we've heard from all of the members of the working group who plan to speak today. Is that correct?
That's correct.
Okay, thank you so much. And I'll just ask committee members if they have any final questions for you.
Madam Chair.
Go ahead, Representative Babbage.
Yes, thank you. I had an aggressive knock on the door that I thought might be an emergency. It turned out to be a bouquet of flowers. I'm not sure if that's for me or not, but I missed part of Ms. Pearson's testimony, and I don't see it written in the, so if she has that able to be submitted, I would appreciate hearing the other half that I didn't hear in person. Thank you.
Okay, thanks. We'll request that. And the other thing is that It's also reviewable on YouTube. So, okay, but we'll ask her for that. Thank you.
Senator Carney, may I offer a quick piece of information regarding the sealing of juvenile records?
Please do.
One point I want to make is that juvenile records that are sealed are nevertheless available to courts, criminal justice agencies, and for law enforcement employment. So a sealing of juvenile record doesn't mean it disappears completely. It just is essentially, it becomes confidential to courts and criminal justice agencies.
Thank you. That's a helpful clarification. Appreciate that. All right, so I'm going to move you back to the panel, and I'm going to ask those who are in the attendee space who are here to testify in support of LD 1676, please raise your electronic hands and keep them raised until you've had a chance to speak. And I don't see anybody else who's here to speak in support of 1676. And so with that, I'll turn to anyone in the attendee space who's here to speak in opposition to LD 1676. Please raise your electronic hand and please keep it raised. And Representative Babbage, did you have another question? You all set? Okay, great. Okay, and so I'll bring Judith Meyer over to the panel. Welcome, Ms. Meyer. You can go ahead with your testimony.
Thank you, Senator Carney, Representative Harnett, and members of Judiciary. Maine Press is here to testify in opposition to this bill, which is an iteration of LD 1964, which you talked about a little bit earlier today. We had testified in opposition of that bill because our members support scrutiny of public records in our courts. And last year, this committee, after learning that Maine Press was not part of the stakeholder group that drafted that bill, assigned Maine Press Association as a stakeholder and asked us to work with a compromise agreement with that work group, which we did over many meetings over a period of many weeks. And this committee then voted to pass that compromise version. So we were surprised to learn that the conversations of that working and stakeholder group continued without Maine Press over this last year. We first learned of the bill on Tuesday when it was posted on the public hearing notification. And I would ask, Madam Chair, could I have more than the allotted 3 minutes since stakeholder Maine Press was excluded from the conversations that brought the bill before you?
Why don't we say that you can have 4 minutes and then we'll reassess. Go ahead.
Thank you. The bill now before you deviates from the compromise amendment. There are new provisions written into this proposal that Maine Press does not support. For instance, the bill adds language that would bar access to juvenile petitions until at least 30 days after the juvenile makes a first appearance. The compromise bill allowed access to the petition as soon as it was filed, which is also current law. This bill also blocks access to hearings until after the petition is made public, essentially blocking public access for 30 days. That is not current law, nor was that the compromise understanding. There's also a paragraph that governs how determinations are made for juvenile case records to be open to the public. And there's a sentence that reads, the juvenile court may restrict the further disclosure, dissemination, or inspection of the juvenile case records in any matter the court determines necessary or appropriate. That was not part of the compromise work, and Maine Press objects to its inclusion. And while this bill does sustain public access for juvenile hearings for crimes that would constitute Class A, B, and C crimes if the juvenile were 13 years and older, there is a brand new public proceedings exception that would allow public access to be blocked if the minor parent, the guardian, or legal custody or custodian requests the public be excluded. This puts the decision on public access on the minor and not on the public and the courts where it belongs. Finally, we reiterate our opposition to the wholesale block on access to all cases where juveniles have not yet reached the age of 13 years without being subjected to a long and unwieldy process of obtaining a court order. If you remember, in 2013, two 12-year-old boys in Lewiston set fire in two separate cases and each were charged with arson. In the first case, the boy burned down 2 apartment buildings and 75 people lost their homes. In the second, the boy set fire to an apartment building, a fire that spread to 3 other buildings, and 100 people lost their homes. In the first case, the case was dismissed because Lewiston police failed to give the boy a Miranda warning. In the second case, the boy was initially found incompetent to stand trial and was held at Long Creek. 2 years later, in an agreement with the county district attorney's office, he pleaded guilty to a felony charge of aggravated criminal mischief and was sentenced to 2 additional years. These cases, both of which were subject to public access in real time, were each handled differently and each resulted in vastly different outcomes. Knowing and fully understanding that process, including the police violation of the minor's basic legal rights, was really important for the public and preserving the foundation of a transparent judicial system. Most importantly, the first case, the boy was white. In the second case, the boy was Black. The white boy received the full support of social services and was placed in a loving foster family, eventually became an honor roll student and a top athlete in his high school. The Black boy was released from Long Creek and has since been in and out of jail. Last May, he was charged with elevated aggravated assault in connection with a stabbing and is now facing 30 years in prison. The public has a deep and tremendous interest in knowing how juvenile cases are prosecuted and how minors fare in our criminal justice system. Do juveniles deserve greater privacy protections than their adult counterparts? They absolutely do. But those protections must be fairly balanced against the public's right to inspect documents and observe court proceedings. The judicial branch has a long-standing tradition of affording real-time public access to records of criminal proceedings, including juvenile proceedings that constitute Class A, B, and C crimes. There are adequate measures currently in place to seal records to protect privacy, and when publication would impede administration of justice. And thank you very much for the extra time. I am happy to answer questions.
Thank you. Let's see if there are questions. Committee members, are there questions for Ms. Meyer? Go ahead, Representative Babbage. And actually, before you begin your question, Representative, Ms. Myers, your testimony has that been submitted through the portal?
It has, Senator
Great.
Carney, yes.
I didn't have a chance to check this morning. Thank you. Representative Babbage, go ahead.
Yes, thank you, Madam Chair. And thank you, Ms. Meyer. I appreciate you doing the deep dive into this testimony. And I'm sorry that you weren't part of the stakeholders group that continued the work. I should have asked this earlier, but perhaps you can help me with the difference regarding, I don't recall the justification for the 30-day delay in access to information. What is the issue there?
Well, that's written into this bill before you. It was not part of the compromise. But the issue, let's take the case of the Lewiston arson cases. These were, there were a series of fires set over a period of 2 weeks. 9 buildings were burned and about 200 people were displaced. The city was living in terror. And it was important to report that charges had been filed and prosecution had begun against the perpetrators, ultimately were discovered to be the perpetrators, in real time to sort of settle the tension in the city. If there had been a 30-day delay, I lived through that. I covered a lot of that. It was a very dark period of time in Lewiston. And in this, what actually happened was that arrests were made very quickly after the arsons. And we knew that. The public was able to learn that. The media was able to report it and sort of calm down the tension. A wait of 30 days would aggravate that tension and possibly, promote additional arsons. There was a string based on kind of police never called it a copycat, but it was a wave of arsons over a period of 2 weeks. So that's my concern with it. It does not allow the immediacy of easing tension in serious crimes.
Thank you for that.
Committee members, additional questions for Ms. Meyer? Not seeing any. Thank you very much for providing your testimony today.
Thank you very much.
And with that, I'll turn to the attendee space and ask anybody who's neither for nor against LD 1676 to please raise your electronic hand and leave it raised until you've had a chance to provide testimony. Okay, I'm moving, there are two people, Catherine McBrien and Julia Finn, and I'm going to bring you both over to the panel at the same time. Ms. McBrien, you can go ahead and proceed when you're ready.
Thank you so much, Senator Carney. I really appreciate you having me here this morning, or I guess almost afternoon. My name is Kate McBrien. I'm a resident of Union, Maine, and I am the Maine State Archivist. I did submit written testimony to you through the portal, so you'll all have that. So I'll just summarize to keep it nice and brief for you. I am neither for nor against this bill, but I just wanted to raise one concern on behalf of the Maine State Archives, that when files like these, case files, are sealed and made confidential, there's usually not a stipulation within the bill that would allow these material to be made open and accessible to researchers years later. And I, as state archivist, have to look at the historical impact, the long term of keeping confidential records. So I fully support the bill in many ways, but I would ask that the archives be included as an exemption so that if there is a time period later on, decades from now, that records could be made available to researchers, that could be included within the bill. The state archives does have part of our statute that 75 years after a record is created, if that record comes to the state archives and is made confidential, 75 years later, it is supposed to be no longer confidential and open to the public. But when that kind of stipulation is not included in original legislation like this, it just creates a lot of confusion and no one's really sure what we can make available, what we can't make available. So if the archives can just be excluded within our 75 years rule, that would be fabulous. And I'm available to answer any questions.
I have a clarifying question for you because I'm not sure I was following. So are you saying if the Maine State Archives is excluded, then the default would be your 75-year provision?
Yes. Yes.
Committee members, additional questions for Ms. McBrien? Go ahead, Representative Babbage.
I just want to ask and confirm that 75-year provision is in statute?
It is in statute, but there's always this confusion about if our statute would take precedence over other statutes of confidentiality. So it's just trying to clarify that.
Thank you.
Any other questions, committee members? Not seeing any. Thank you so much for being here and providing your testimony.
Thank you. Thank you. Have a great day.
And Ms. Finn, welcome back to the Judiciary Committee. Excuse me, you can begin your testimony whenever you're ready.
Thank you and good morning. I think it is still morning, just barely.
Barely.
Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. My name is Julie Finn and I am here today representing the judicial branch. I reside in Portland and I am testifying neither for nor against this bill. As others have noted, this bill has been reviewed and revised with stakeholders over a considerable period of time, including in the 129th legislature as LD 1964. We have appreciated the opportunity at times to participate in these discussions. In addition, we very much support the worthy goals of the bill to make the juvenile justice system rehabilitative rather than punitive. The judicial branch, however, is the entity that will be charged with implementing this legislation. If the bill becomes law, our judges and clerks will have to learn and be trained on the new procedures outlined therein. As a result, we are in the process of conducting a detailed review of the 18-page bill and have detected some procedural issues that we wish to discuss with the bill's proponents. We have in fact already taken steps to set up that meeting. And after completing this review and discussion, we anticipate that we may have an amendment to offer at the work session if we could ask for your indulgence in that regard. Thank you very much for your time today, and I'd be happy to answer any questions if you have any for me.
Thank you very much. I'm going to start out with a question. Do you have an idea of how much time you'll need to complete your review before being in a position to propose an amendment possibly?
Well, our staff has completed it. I am planning to discuss it with judicial branch leadership, the judicial officers, Monday morning at 8 o'clock. The dates that are being tossed around for a meeting next week vary from Monday afternoon to a few days after. We will try to get that meeting accomplished sooner rather than later. So to answer your question, I think we're talking a matter of days and are aware of the urgency of the calendar at this point, and we'll work on that ASAP.
Thank you very much. Yes, so I would just ask that you be in touch with our committee clerk and with co-chair Harnett and I so that we can schedule it appropriately.
Absolutely.
Committee members, are there additional questions for Ms. Finn? Not hearing any, and so thank you very much.
Thank you.
And with that, we have completed all of the testimony on LD 1676. We'll close the public hearing on LD 1676. And at this point, we have a half an hour. We have 3 more public hearings scheduled for today. And the next public hearing is 1438. And I would like to the committee to be able to keep moving forward and do this public hearing. And if that is acceptable to everybody, then we will move forward. And Representative Harnett, my co-chair, I saw you giving the thumbs up. Would you open the hearing, the next hearing? I need just a few minutes of break, please.
Absolutely, Senator Carney.
Thank you.
And welcome. The next bill for public hearing is LD 1438, which is a resolution proposing an amendment to the Constitution of Maine to declare the natural, inherent, and unalienable right of enjoying personal privacy. And I welcome or ask the committee clerk to move over the bill's sponsor, Representative Fecteau of Augusta. And Representative Fecteau, whenever you are ready to go, just unmute your microphone and begin your testimony when you feel comfortable, and welcome to the Judiciary Committee.
Thank you, Representative Harnett. I heard this committee hasn't had enough bills, so I decided to submit another one for you guys just to even it up. You know, I want to make sure all the committees are even. So I still have like 20 seconds, so good morning. Mr. Chair and my colleagues on the Joint Standing Committee on Judiciary, I'm Justin Fecteau, and I proudly represent House District 86, which consists of the western and northern portions of Augusta. And I proudly give testimony in support of LD 1438, which is a resolution to include the enjoying of personal privacy to our natural rights. So I've long been passionate about privacy, and the thought to submit this legislation was by one of my friends and fellow residents of Augusta. Maine has a wonderful and prescriptive constitution. Article 1, Section 1 lists important natural rights we all cherish: life, liberty, property, safety, and happiness. These are all wonderful things. However, I contend that unless privacy comes with this, then these inherent and inalienable rights can never reach their true potential. Privacy is something I take seriously, and it's something that the US Constitution mentions in passing a few times, but never outright says it. In the First Amendment, we have the right to choose any religious belief and keep it private. The Third Amendment provides us the sanctity of our own private homes. And the Fourth Amendment protects us against unreasonable searches and seizures. I believe we need to outright say it, especially in the digital age, when what used to be unknown and off limits is quickly becoming known and even public knowledge. That's why I believe it's important to enshrine it in our Constitution. I appear in front of this committee today with an extensive anti-privacy background. Let me explain. 15 years ago, or 50 pounds ago as I see it today, I joined the US Army to become a military intelligence soldier. I deployed twice for a total of 27 months to Iraq, and I completed 6 total years of service. After the Army, I served as an intelligence advisor at the National Reconnaissance Office in Northern Virginia. For those that don't know, it's our nation's spy satellite agency. Throughout my time in service, I was able to perform and experience the full breadth of the US intelligence arsenal. We're talking satellite imagery and drone footage, attack radar, signals intelligence, psychological operations, human intelligence reports, lethal and non-lethal targeting, the works. I know things about people, locations, operations, and events on this planet that would send a chill up your spine. And it just wasn't what I was doing, it's what our government was doing abroad, and some of what they're likely doing here. Without a person's knowledge, I could know where they slept, where they lived, when they were and weren't at home, who they spoke with, what they purchased, their hobbies, interests, religion and place of worship, their friends and business acquaintances, what they drove and how often they drove their vehicle, their eating habits and when they shopped for their food. With a list of compiled information, we were able to conclude what made them happy or sad, their political leanings, how much they love their children, and when we could even predict their likelihood of doing certain things, on which days, at which times, and how often. I think we can all surmise that almost every single one of these things is off limit to government knowledge. Even more so when we find out that our government knows too much about us, or heck, even our phones. It's scary, creepy, and intrusive. Even if some information is publicly available, we know that that government has the capability to catalog it, database it, or even weaponize it. That's intelligence collection, and it's wrong. Using publicly available information, I was able to determine the best way to approach the residents of Johnny Sixpack, and if I was approaching on foot with a tactical team. It's public information, and as the government, I might need that information, so I'll just catalog it, match it up with his kid's school schedule, his work schedule, and cell phone tracking data that I purchased from Google, so I know the best day and time to catch him at home. With a simple algorithm, I'd be able to determine a lot more than that. It's for your own good. What happens when Maine CDC's Sarah alert system to assist with contact tracing, which I also have huge privacy concerns with, isn't shut down because it's for our own good? Our government would be able to match it with social media check-ins for our own good, and then share that information with state health insurance because Representative so-and-so has been frequenting too many places that jeopardizes costly medications to keep his heart condition or cholesterol under control. Or social media algorithm that showed up that Representative whatchamacallit was drinking a beer in a photo and they've been stung for a DUI. So an automatic text message goes out to remind them to get a DD on their way home for their own good. We've all heard reports, albeit I won't be the one to confirm their validity, about a Maine-sponsored program tracking people performing their constitutionally protected First Amendment rights, and then some of that data may have been breached. The Bangor Daily News told us last April that cell phone data showed that 40% of Mainers weren't leaving their homes. But don't worry, it was the governor's orders, you silly goose. Tracking cell phone data is what the government has to do sometimes. Stop worrying, it's for your own good. This isn't the first time this administration has attempted to track our whereabouts with cell phone data. The governor also wanted to know about your driving habits so they could tell the start and end points of your travel, speed, trip length, and even provide data on their turning movements. This data could also infer the purpose of the trip. But calm down, you InfoWars conspiracy theorists. It's to save the planet or whatever. And plus, they contracted that work out, so the government wasn't even doing it. In all seriousness and without sarcasm now, this is scary, creepy, and we need to cement it in our Constitution so it will never happen again, to include the subcontracting of the intelligence collection on American citizens. I'm certain other administrations have been up to no good. The incidents I mentioned earlier were just timely. When it comes down to it, big tech and big data have these tools and they're willing to sell them to our government for their use. While the government will use it for one purpose, big tech and big data will use it for another. As someone who has worked with lots of data in the Army, there is no such thing as having too much information about a person or even the most mundane facts. And even the most mundane facts could be weaponized. Additionally, it's my opinion that the passive surveillance state is breaking the Third Amendment to the US Constitution, where it states, "No soldier shall, in time of peace, be quartered in any house where the consent of the owner, nor in time of war, but in a manner to be prescribed by law." I believe passive surveillance in the digital age means that government agents, either outright or through purchased data collected by a third party, are quartering soldiers in our own homes. There's nothing seemingly careless about the databasing and cataloging of everyday information about Maine citizens. I believe it's our right to personal privacy of all kinds, my home and personal life, my hobbies and legal activities, and my thoughts and inner life. The simple word and right to privacy is nowhere to be explicitly found in our Constitution. Please help me change that. And with that, you will also hear another bill today proposing an amendment to our Constitution concerning privacy. And I don't want this bill and that bill to be seen as competing. I think it's showing that there's strong bipartisan support for protecting our privacy in the state of Maine. And I look forward to working on that with that sponsor. And so with that, thank you for your time and consideration.
Thank you, Representative Fecteau, for bringing this bill to the committee's attention. We greatly appreciate your time and testimony today. And before turning it over to the committee for questions for the bill sponsor, Representative Fecteau, I'm going to turn the gavel back to Senator Carney, and also let those in attendance know that I may have to leave to go to another committee any moment now, but I will stay as long as I can. I would ask my colleague, Representative Moriarty, to take over the timing of witnesses. So, Senator Carney.
I was muted. Thank you very much, Co-Chair Harnett. Looks like there are a number of questions that committee members have for you, Representative Fecteau, and I just wanted to welcome you and say hello to my seatmate from the 129th. Representative Evangelos, please go ahead with your questions.
Thank you, Madam Chair. Just two quick ones. Hi, Representative Fecteau. That was very effective testimony, by the way. Have you filed for whistleblower protection?
I have never filed for whistleblower protection.
Okay. Just was curious because I know people in similar circumstances with what you've revealed have, and so just care about you. That's all, for being courageous to tell us what you told us today. Thank you for that. Do you have any additional information regarding the activities of the Fusion Center that have not been disclosed publicly, that given your area of work and expertise in this area?
Thank you for that, Representative. I've long been passionate about monitoring the activities of fusion centers. I worked in a fusion center. I know what they're capable of doing, but it all depends on what tools are being shared and what data is being shared back and forth. I fear, as an intelligence soldier, what we could be up to. I fear that a lot, especially with coordination with the Department of Homeland Security. I fear that a lot. I don't want to say what anyone's doing because I don't know additional information, but I know the full power of the intelligence arsenal, and a fraction of that is being used on American citizens. It's scary.
Thank you for that, sir.
Thank you.
Representative Harnett, I think your hand is up from timing. I just wanted to check in with you. Senator Keim, go ahead with your questions.
Thank you, Madam Chair. Thank you, Representative Fecteau, for bringing this bill. My question is, whenever we put language in the Constitution, it's not just the language, right? It's how it later gets worked out in the courts. And just wondering, have you had any feedback from folks on any language and what they see as problematic?
Thank you, Senator. I know the next representative sponsoring the next bill has had a lot more interaction with the constitutional legality of words. Words mean a lot, and they mean a lot in the Constitution. And I take that just as seriously as my oath to office. Things have to live long and beyond me. So I am very, very careful, and I would be very, very cautious about adding any word to our Constitution.
Yes, thank you for that perspective.
Representative Babbage?
Thank you, Madam Chair. Representative Fecto, relating to the privacy issue in your bill, which is so consequential. The whole idea of the fusion centers as part of international security, I mean, the national security, is the sharing of information among the various intelligence communities within the country. Are you concerned that the sharing of that information is inconsistent with the welfare of the country? In other words, is this privacy proposal related to a potential concern about the greater availability of that information among the intelligence communities?
Thank you, Representative. That's a very complex question.
I would love a two-word answer.
I can't give you a two-word answer, but I completely respect and understand the United States mission to protect us against domestic terrorism and imminent threats of violence against our people. At the same time, I don't think that legal and constitutionally protected activities or mundane facts about our lives should be databased and cataloged and shared all over the place.
I guess my question was is the sharing of information in your experience, having worked in a fusion center, too easily obtained? Or is that information duly protected, in your opinion?
By and large, it is duly protected. By and large, the issue becomes when those centers or information is not used on closed networks. The military uses closed networks, so that data has a lot more protections. Some of the issues that I have is the subcontracting of information, where essentially we use big tech and big data to do the bulk of it, and we're just paying for it. So some really skirting the safe protection of highly sensitive materials to protect public safety.
Thank you for
Representative Thorne, you can go ahead with your question.
Thank you, Madam Chair. Welcome, Representative Fecto. Long time, first time. Thank you for your service. I have a two-part question for you. One is, has anything like this ever been introduced in Maine legislature that you're aware of?
Not that I'm aware of, but I'm a short timer here. I'm sure the law library would give a much more coherent response than the one I just gave you.
All right, thank you. And my second part is, are you aware of any other states that have incorporated something like this similar?
I have not done a 50-state analysis on this as well, Representative. Thank you.
That's your assignment.
Yes, sir.
Thank you, Madam Chair.
You're welcome. Committee members, any additional questions for the bill sponsor? Not seeing any. Representative Fecto, we typically let sponsors stay on the panel while folks testify, and you're welcome to stay if you'd like.
Thank you, Senator.
And we have, I think, one person who signed up in advance to speak in favor, and I believe that's William Clardy. Mr. Clardy, if you can, okay, great. I will move you over to the panel. And Mr. Clardy, you can activate your audio and video whenever you're ready. Welcome to the Judiciary Committee.
Thank you.
You can proceed.
Thank you. I will try to keep mine short and sweet, or my testimony short and sweet, hopefully well under 3 minutes. And I do hope there will be questions. Maybe I won't, maybe I'll be able to answer all of it in advance. And I want to thank Representative Fecto for sponsoring this bill and bringing it forward. Even if I do live on the wrong side of the railroad tracks, I still count him as a good friend. But I would also like to bring this up as a more than just a question of government intrusion on privacy, because privacy is actually a much broader issue overall in our legal system. It's not just search warrants. There's in answer to one of the panelists or one of the committee members' questions, fewer than half the states actually even mention privacy in their constitutions, and most of those limit it to some variation on enhancing their prohibition on warrantless searches. But privacy is actually a lot more than that. It first got recognized as a formal right back almost 60 years ago by the Supreme Court in terms of contraceptive rights, where they decided that a couple's right to use contraceptives was a right that, you know, it's a personal right that they were entitled to make, and they couldn't find any written proof of it in the Constitution. So they looked around in penumbras and emanations, and in Griswold versus Connecticut, they decided, no, the state can't outlaw the use of contraceptives or the distribution of contraceptives. A few short while after that, again, it cropped up when they said that marital right to privacy meant the state couldn't prohibit interracial marriages in Love v. Virginia. There is medical privacy, you know, what you tell your doctor or your therapist, the discretion required for that, and the sense that that is also private information. You know, if you're Catholic, anything you say in the confessional, that's part of your right to privacy. It's a very broad issue that touches on every aspect of our lives. And that's part of why in 1438, the language is very simple. It's just, there is a right to privacy, and we're not trying to limit it to just protection from the government, but respect for all our rights, all our individual rights to conduct our own business in our own personal way. This is actually the major contrast between LD 1529 and 1438, in that 1529 goes into a bit more explanation about electronic searches and electronic privacy and focuses on that. And one problem with that is that, especially in constitutional language where judges look for broad principles that can be applied, when you start explaining and picking out, this is what we're talking about, that also provides a guideline for lawyers anywhere to, oh, well, this is how we work around that. And this is the limits of that. So if you emphasize internet privacy or internet communications as being private, what does that mean that if I'm in a shouting match with my former best friend about his political candidate of choice in my backyard, do I have a right to expect that my neighbor can't live stream our argument to all his friends with a running commentary and have it go viral? That's where keeping it broad, keeping it simple, and trusting judges to use their discretion in enforcing it. I'm reminded of a story way back when I was studying to be a reporter in the AP Style Journal, where they talked about a lady, I believe it was in Montgomery or Birmingham, some southern state or southern city. They were having a heat wave, and the local paper sent a photographer out to get pictures of the heat wave and people dealing with it. This woman was sitting on her front stoop in her house coat, hair up in curlers, fanning herself. Photographer came by, and her picture was on the front page of the paper the next day. And she obviously was a little upset about that because she didn't know she was going to show up on the front page of the paper looking fresh out of the shower, or not even fresh out of the shower. The court, the judge, when she sued the paper for invading her privacy, said, well, yes, sitting on your front stoop, you weren't doing anything newsworthy. You didn't think you were being a public figure. You had a right not to expect everybody to see you in that condition. And sided with her. And
Mr. Clardy, I'm sorry. We typically run a 3-minute timer, and I think our system's a little apart on this one. So if you could just take a sentence or two to wrap up, please, we'd appreciate that.
Yeah, really, honestly, the big thing is on the right to privacy, it's a broad right. It should be a broad right. It belongs up there with the A list of life, liberty, the rights that are only limited by when they impede on other people's exercise of those other rights. And so if you, for 1529 and especially for 1438, either one is a win, but keeping it simple and not getting too much into the details on it would be the better bet. And I apologize for running over. If anybody has any questions for me, I'm ready to deal with that. Other than that, thank you very much.
Thank you so much. And you don't need to apologize. It was a malfunction on our end. So we appreciate you being here. Committee members, are there any questions for Mr. Clardy? I am not seeing any. Go ahead, Representative Moriarty. We're not able to hear you, Representative.
Sorry, I didn't know that was on. Mr. Clardy, I remember the 1965 Griswold decision from the U.S. Supreme Court establishing a constitutional right to privacy. In the years since, are you aware of any decisions of the court cutting back or limiting the scope of Griswold?
Not of any cutting back the scope of Griswold per se. I know that there have been well, I shouldn't say countless, but there have been lots of decisions making distinctions versus Griswold and others that have built on Griswold. So honestly, I just see this as at least anchoring that right in some constitutional language so that we don't have a repeat of Judge Bork 30 years ago pointing out, hey, it's not really written in there anywhere. So I hope that answers your question.
It does. It does. Thank you.
Thank you. And not seeing any other questions. Thank you very much, Mr. Clardy, for providing your testimony today. I did want to note that as Mr. Clardy mentioned, he mentioned the second bill we have that relates to a right to privacy. That's LD 1529. And I know that typically, well, first of all, we don't have anyone else, I believe, signed up to testify on 1438. So just let me check. I know that Dan Chase has raised some concerns and he's signed up for the second bill, 1529. But is there anybody who signed up for 1538 who's in the attendee space? Not seeing any. And Mr. Chase, your hand is up. Would you prefer to testify on this bill 1438? I'll bring you over from the waiting list to see if you are. And also I wanted committee members to, while he's in cyberspace, to please consider, I know that we typically finish up after a half day on Friday so that we can all attend to other legislative business. I do think it would make a lot of sense to keep moving forward and hear 1529 at this point. So please think about that as we proceed with our next person who's here to testify. And Mr. Chase, you are here, and I think you signed up for 1529. This is 1438. They're related to each other, so you can speak to both of them if you'd like.
Okay. Justin put forth a good bill. I have two concerns with it. One, it says individual privacy. No, it doesn't. It says personal. It needs to be individual because the court will screw with the words you used. So please just amend that. The second is the word of. I'm afraid that the court will say, well, it's of this, but it's not directly this, therefore it doesn't have to apply. So please remove the words of and change it to individual privacy instead of personal, just for those two reasons, simple amendments. As far as the second bill, it's got flaws. The biggest one being Maine Constitution, Article 1, Section 24, the rights enumerated above shall not be used to remove rights. Well, now we've got one below it. That needs to be modified to say, other rights being enumerated shall not be used. And then they're both all in the right direction. I'm absolutely in favor of the right of privacy. Many of you don't know that the decision in Roe v. Wade was based on privacy. The court decided it's in the penumbra of rights. What's that mean? I ain't got a clue. They just take and reach out and say, it sounds good to me. But privacy has been recognized, but because it's a court-created bullcrap, they can say, we were wrong in that bullcrap. We're going to take it away. When you put it in the Constitution, it's no longer bullcrap, but they can choose to keep it going.
If you can just keep your I'm sorry, go ahead.
I'm pointing out the results of the bill, ma'am. By putting privacy in the Constitution, the judge cannot say, we erroneously declared you had privacy rights earlier. It's now in the Constitution, so that locks the judges in. And as far as amending the Constitution, I'm not against it, as long as it protects the right of the people against the government. And these bills, both of them are excellent ideas. It just needs to be individual privacy and remove the word of to make sure that it isn't related to it, but it is this thing. I've read too many cases where judges have said things that don't make any sense because they play with words. Any questions? Ask me.
Thank you very much, Mr. Chase, for your testimony. Committee members, are there any questions for Mr. Chase about either 1438 or 1529? Not seeing any questions, Mr. Chase. Thank you very much for providing your testimony today. And with that, I'll just do a final call. Is there anybody on the attendee panel who wishes to speak in support of 1438? Or in opposition to 1438? Or neither for nor against 1438? I'm not seeing any raised hands. So with that, we'll bring the public hearing on LD 1438 to a close. And Representative Fecteau, thank you very much for bringing this legislation forward.
Thank you very much. And make sure you thank your mothers. Don't do the stupid thing. Thank your mothers. Have a great weekend.
Great parting words. Committee members, is everyone okay with continuing to go forward? I know that you may have meetings and stuff set up this afternoon, but if it's okay with you, you can nod if it's okay. Great, let's keep going. And so we have, that closes our hearing on 1438. We're opening the hearing on LD 1529, and I'll bring the bill sponsor over. And so we're opening the public hearing on LD 1529, a resolution proposing an amendment to the Constitution of Maine to grant a right to privacy, and the bill sponsor, Representative O'Neill, is here. Welcome, Representative O'Neill, and you can proceed when you're ready.
Thank you. Good afternoon, Senator Carney, Representative Harnett, and members of the Judiciary Committee. I am Maggie O'Neill. I represent House District 15, which is in Saco. Thank you for the opportunity to present LD 1529, which is a resolution proposing an amendment to the Constitution to create a right to privacy. As background, this year, I am not a computer person at all, but I had the chance to take classes at Maine Law's privacy program. And it just happens to be a top program in the country. So I kind of dug into it because I was surrounded by a lot of people that were interested in these issues. And what I want to direct you to is it's finals right now. So so my fellow students that are experts on this and professor have submitted testimony or will this weekend. So I just encourage you to take a look at that because they are really good resources. And the professor may be available for the work session if that would be helpful for the committee. And I want to note too, before I start, that Representative Fecto and I learned that we were both interested in privacy protections and decided to partner on this issue because it really speaks to the core of who we are and how we live our lives as Mainers. So to start, here are the basics of what I learned about common law regarding privacy. So first, privacy isn't explicitly protected in the US or Maine Constitution, but protections do exist. Second, as a result, courts have developed constitutional privacy jurisprudence in a piecemeal manner. And third, until the CCPA's recent passage, statutory privacy law in the US has been sectoral, creating a tailored but piecemeal system of privacy protection that's insufficient on its own to respond to changes in technology. Fourth, I want to share that some state constitutions do incorporate additional privacy rules beyond federal provisions. That's where we come in with this proposal today. And finally, that constitutions in other countries have more expansive and more explicit privacy rights. So I'll open up by talking about privacy protections in the US Constitution. Like I said earlier, privacy is not explicitly protected in the US Constitution. There are different elements of privacy that are akin to slices of a pie that are protected. So for example, the Fourth Amendment protects against unreasonable searches and seizures, as you know. Maine has an equivalent that requires that warrants are based upon probable cause and define the scope of a search or seizure with particularity. Fourth Amendment protections mostly come up over admissibility of evidence in criminal cases. Other slices of the pie include intellectual privacy, which is essential for sustaining free expression under the First Amendment, bodily autonomy, you can see Griswold and substantive due process cases, sexual privacy, and preventing the disclosure of sensitive personal information. And what I didn't note, but do want to note, is that it can tie into discrimination as well. Those protections are currently supplemented by sectoral privacy laws related to the type of data or processing taking place and consumer protection law. You're well aware of HIPAA, for example, as it protects certain health data. This complex piecemeal approach could be strengthened and clarified with an explicit right to privacy at the state level. Constitutional privacy amendments provide a broad overlay of protection, while statutory protections are fragmented and target specific areas, as mentioned, health or financial as an example. A constitutional amendment creating a general right to privacy would provide a backstop to constantly emerging technology in an economy saturated with and driven by the collection, storage, and use of our personal data. So moving on to state constitutions. Most Mainers would be surprised to learn that privacy isn't explicitly protected in our Constitution. I'm told by those who know better than me that there isn't an extensive amount of constitutional case law here in Maine. I'm not aware right now of any jurisprudence on the right to privacy under the Maine Constitution, and I'm working to bring that answer for the work session. The norm is likely to be in line with or extend to state constitutional protections beyond federal constitutional protections. So I'll cite, I won't read it all, but in my testimony, I cite other contexts where Maine's courts have held that the Maine Constitution does provide additional guarantees beyond those contained in the US Constitution. And I've cited to, when New Hampshire and Vermont and Massachusetts have done the same. So that it's possible, but that we have limited case law. There are a number of states, about a dozen, maybe 13, that explicitly protect privacy in their constitutions. The constitutions in Alaska, Arizona, California, Florida, Hawaii, Illinois, Louisiana, Montana, New Hampshire, South Carolina, and Washington all have explicit provisions relating to a right to privacy And I've included a table from NCSL that has all of those provisions. And a second part, which I've included in what I'm proposing here today, is that Michigan and Missouri each have constitutional amendments that provide explicit protection from unreasonable searches and seizures for electronic communications or data. The privacy protections afforded in some of these states mirror the First Amendment of the Constitution relating to the search and seizure or government surveillance, but add more specific references to privacy, shown in italics in that chart. In addition, more general provisions in other states have been interpreted by courts to have established privacy rights of various types, which you can also see in that attachment. And the two Fourth Amendment additions that are Fourth Amendment equivalents that I mentioned were adopted in 2014 in Missouri and 2020 in Michigan. I think it was like 75% in Missouri that approved it. I don't remember offhand for Michigan. And New Hampshire had this on the ballot in 2018 to create a more general right to privacy, and that passed with 81%. So I will go over what the actual language is that I'm proposing. So like Representative Facto, the language starts by adding privacy to the natural rights clause. The reasoning behind that is that privacy is a fundamental human right that really does belong in the same category as the rights that are enshrined there. Adding privacy makes explicit what I think already exists implicitly in that clause. So as mentioned, Representative Facto and I have coordinated on this, and I'll speak for myself, but I'm committed to supporting the work of the committee to advance this amendment, you know, whether it's in his form or mine or some combination thereof. All right, the second element would create a right to privacy for Mainers against government and the most powerful private actors. So first, making an explicit right to privacy creates a general right and a backstop, as opposed to the piecemeal approach currently made up by the non-explicit constitutional protections and the statutory protections that I've mentioned. Historically, societal threats to privacy have really arisen unpredictably from emerging technology, from the instant photograph that Brandeis talked about in 1890 or around the turn of the century, to wiretapping, to apps that data mine on our smartphones. This is true both in a search and seizure context and in the rise of what's been diagnosed as surveillance capitalism. The giants in today's world economy are those who have mastered the collection and use of personal data, such as Google, Amazon, and Facebook. Those giants have built the monetization of personal data into their business models by offering a product or a service and collecting data as a byproduct. Harvard business professor Shoshana Zuboff has identified a global economic shift comparable to the Industrial Revolution. Companies like Google design products in order to obtain what could be called behavioral surplus, or data that's generated from your primary activity. So you might be conducting a search on Google, and it will make use of your search terms, the links you click, how many results you view, how quickly you type. And that information is then used to create value via targeted advertising and making predictions about behavior. In the face of this shift, we need to fundamentally rethink our old frames to recognize what's at stake and to create protections. Because there's so much money to be made in this new economy, the incentive is always to create new technology that creates new ways of gathering data. From apps that collect your locational data or perfect facial recognition technology by putting bunny ears on your head and a little nose, to digital watches that monitor your health information and collect data as exhaust, to smart home devices like Alexa that have an active microphone and are connected to a network. The privacy risks faced by Mainers and people around the world are more complex, more systemic, and potentially more harmful than ever before. This amendment could be used to protect Mainers from the worst of the privacy abuses that we've seen from big tech and social media. And then the third and final component is that this amendment would require the government to get a warrant before obtaining personal electronic data and communication when it's held by a third-party service provider. In other words, the goal is to extend the Supreme Court's ruling regarding CSLI in Carpenter to apply to other types of electronic data and communications. Prior to the digital age, privacy was protected by the difficulty and the cost of surveillance. For example, prior to technology changes, if law enforcement officers wanted to observe a person's movements on public roads for a month, that would be, costly, burdensome, and difficult to execute. So you might have to pay officers to observe, a person over a month's time. You have a team of 20 people, and that observation would obviously be in real time and potentially detectable by members of the community or by the person being observed. It's a totally different ballgame when agencies are able to, tap into our electronic data. Surveillance can be remote, instantaneous, very inexpensive, and undetected. In 2012, Justice Sotomayor warned that this kind of monitoring is just like I said, it's inexpensive when compared with conventional surveillance. It proceeds surreptitiously, not checked by resource constraints, community hostility, and opportunity to observe surveillance activity. It can generate incredibly sensitive data about family, work, politics, religion, sexual life, and association. And as such, these powers of observation are susceptible to abuse. It doesn't mean necessarily it is being abused, but it's susceptible to that. So I don't want this to be read as an accusation for anybody listening, but just a reality of a vast power. And the awareness that agencies may be watching, she adds, also can chill associational and expressive freedoms. In the age of new technology, unless we're, somebody like Ron Swanson, totally off the grid, we all reveal an incredible amount of information about ourselves to third parties just by carrying out mundane day-to-day tasks. Something that we've learned from Fourth Amendment privacy jurisprudence is that it's really hard for the legislative branch to keep up with emerging technology. It was hard 100 years ago, and it's especially difficult now. Back in 1928, Justice Brandeis, again, one of the fathers of privacy law, outlined that the purpose of the Fourth Amendment is to protect against government abuses of power, and the amendment must be able to adapt to a changing world. He warned that with technological advances, subtler and more far-reaching means of invading privacy have become available to government, and suggested that as technology changes our world, the Constitution and the Fourth Amendment need to be able to adapt to protect our privacy rights. The speed at which technology changes today creates a gaping need for a backstop that creates protections when we have gaps in the law. Since the 1970s, the Supreme Court has created and perpetuated a legal doctrine known as the third party doctrine, under which people who voluntarily give information to third parties, such as banks, phone companies, ISPs, email servers, don't have a reasonable expectation of privacy in that information. This amendment would clarify that government actors need a warrant to obtain information from third parties. And there's agreement that the law should be moving in this direction. Most notably, if you see Carpenter from 2018, and then leading up to their concurrences and dissents in the years prior. And there's just a general sentiment that search and seizure protections have to be adapted to protect privacy in the digital age. So as I noted, 2 other states have already adopted this language in their own constitutional equivalent of the search and seizure protection, beginning with Missouri in 2014 and Michigan in 2020. As many of you know, the warrant requirement really is about balancing privacy rights here against competing interests of public safety. This particular idea actually came out of conversations with a fellow law student about how warrants really are a low bar, and that officers in Maine, for the most part, should be doing this already. He had a cool perspective because he had worked in law enforcement for 20 years and was getting his law degree. It was cool to go through this class and have these conversations with him. So the warrant requirement is really, it's about going through a formal process where an officer sets bounds around what's being searched, a time frame, and showing why the search is needed. That particular officer, the one from my class, actually wondered whether it was enough of a protection depending on the scale and the kinds of the data being searched. So not all the time, but there might be certain instances where it's just not enough based on the scale and the sensitivity of data. To conclude, privacy is a massive concern, and it's also an opportunity. The protections aren't explicitly stated in our federal or state constitution. Our privacy laws are sectoral, creating a patchwork, and those laws are always outpaced by developing technology. Clarity will help protect our privacy interests as technology continues to evolve, and laws will always have to keep up with those changes in technology. And the last thing that I'll add is, that's it. I'm sorry. I have exam brain, but that's really it. I think I have a little more, but I know you guys are at the end of the day. So, and the testimony I'll attach will have information from other states and then a couple other things. So thanks for your time and consideration.
Thank you, Representative O'Neill. I was going to ask you, are you still in exams or are you done with exams?
No.
Oh, goodness. Well, thank you for presenting this testimony today. I'm just going to jump in with a question because it's something that you kind of raised in your testimony. You were talking about how it's hard for the legislature to keep up with emerging technologies. And I think the difference between your proposal and Representative Fecteau's proposal is that you kind of explicitly call out digital information and electronic communications. And do you think that it's important to specifically reference that in a constitutional amendment as opposed to leaving it to the courts to elaborate on the specifics of the right to privacy?
I do. And what I can do for the work session is really go through the case law and bring some citations of dissents and concurrences leading up to Carpenter, and then also what was in Carpenter, because I think you'll find it really useful to see how there shouldn't be this distinction that just because your information that would have been in your desk drawer in the 50s now lives here.
Mm-hmm.
So I think making that explicit, just based on the scale of all of our personal data and lives that are out there right now, it's essential, and it's coming, but why not give Mainers that protection now?
Thank you. Committee members, are there additional? I see that there are additional questions. Go ahead, Senator Sanborn.
Thank you, thank you, Senator Carney, and thanks, Representative O'Neill. I have sort of a silly sounding question, but I actually would love your thoughts on it. So if we pass this and then adopt it as a state by vote of Mainers, is it illegal to sell an Alexa in Maine?
I don't think so. I think what, so let's back it up. It'll be up to a court, just like any other issue, to define what that privacy right is. And obviously, rights have to be enforced, right? So somebody would even have to bring a case to question any kind of activity.
So as a follow-up, should it be up to the courts or should it be up to the legislature to determine what the parameters are by which Alexa should be allowed to obtain our consent, for example, or Google or whomever owns Alexa should be allowed to obtain our consent, whether that should be an opt-in or an opt-out, whether it's okay to have click wrap, whether it's okay to ask us on a screen, or whether we have to do it in writing. Should that be up to the courts or should it be up to the legislature?
I think that's a great age-old question, right? And we can look to parallels in environmental law, I think, for a really good comparison. What a constitutional amendment, I mean, it can do different things, but I'm seeing this as a backstop, as a floor. What can't we go beneath? And I think a court can determine that. I think more detailed regulation, yes, belongs in a legislature. And I don't think courts are going to want to do that, just like we've seen in environmental law. You look at, I'm trying to think of different cases about climate change, and they said, no way, we don't want to touch this and regulate here. But they will look at maybe a floor that things won't go beneath.
So we would still need sector specific laws passed by the legislature and regulations written by the executive branch. Is that accurate?
It's all a big picture that works together. I see a constitutional right as a backstop. And then the kind of detailed day-to-day regulation, I mean, that's a policy question, Senator Sanborn, that people debate every day. Whether we should have a general privacy law, whether we should have a sectoral approach because maybe it can respond better. And certain sectoral laws do function really well in a way that maybe the GPDR or CCPA don't. A lot of people criticize, different aspects of both sectoral laws and generally applicable laws. Sometimes it's hard to do it all with one general law. But I guess the point is that, yes, all of these things function together. Privacy is always changing, incredibly technical. But the takeaway that I want to have here is that as technology is changing, new things are emerging, there are new areas to conquer and collect data, that just because we don't have a law in place doesn't mean that we don't have some kind of floor that you can't go beneath.
In your view, Representative O'Neill, would a right to privacy also protect information about one's hormone levels?
Hormone levels?
Mm-hmm.
That is specific, and I hadn't thought about it, but I would think that health data, yes, should be protected. I think whenever you're talking about privacy, you need to think about like what's the harm, what's the use of the data. Yeah, there's a lot of context to facts. But
thank you.
Committee members, additional questions for the bill sponsor? Go ahead, Representative Moriarty.
Thank you, Madam Chair. Representative O'Neill, I want to ask you about one of the elements of your definition of privacy, specifically the reference to personal thoughts or inner life. There was an article on the front page of the Press Herald this morning about the arrest of a Maine man in New Hampshire, based upon information given to the authorities by his employer. And the employer had observed really disturbing changes in this person's behavior and comments at work in recent weeks, and apparently had received from an anonymous source a sketch portraying a weapon of some type and another individual within the workplace and alerted the authorities. If someone, through disturbing comment or behavior, causes another person to feel that there is the potential for a public safety threat evolving, do you intend to suggest that that sort of information, that sort of reaction to what one is hearing is something you can't act upon because it reflects personal thoughts or inner life?
Thank you for the question, Representative. And it's thoughtful, current. I like the idea of connecting it to something current. So whenever I frame a privacy question, it's always, like I said, what's the harm? What kind of other interests are we balancing? And I think that's, that's normal for an individual right to look at what you're balancing it against. In the law enforcement context already, Fourth Amendment jurisprudence, balances search and seizure protections against other public safety needs. Do I think that a general right to privacy would make it so that, if I understand correctly, was it an employer, a colleague, a friend
An employer.
An employer couldn't communicate to authorities to say, I'm worried about this person?
Right.
I mean, I think if it's something that they observed and were able to observe, and they were concerned about safety, why not?
Okay, thank you. Thanks for your answer.
I mean, yeah, I think if I could process a little more, it's just making a report, and then that agency can decide what they want to do with that information.
Thank
you both. Any additional questions for the bill sponsor? I am not seeing any. Representative O'Neill, we do allow sponsors to stay on the panel while we hear additional testimony, so wanted to let you know that you're welcome to remain on the panel. And I'm going to start by bringing over those speaking in favor. So for anybody in the attendee portion of the meeting who's here to speak in support of LD 1529, please raise your electronic hand and keep it raised until after you've had an opportunity to speak to 1529. I see that Representative Fockingham wishes to speak, and so I'll bring him over to the panel.
Good afternoon.
Welcome, Representative Fockingham. We're pleased to see you. You can begin your testimony.
Thank you. And good afternoon, Senator Carney and members of the Committee on Judiciary. I am Representative Billy Bob Fockingham, and I am here to speak in support of LD 1529, a resolution proposing an amendment to the Constitution of Maine to create a right to privacy as a co-sponsor. I am incredibly honored to have the opportunity to be a co-sponsor on this bill. This resolution proposes to amend the Constitution of Maine by creating a natural and inherent right to privacy in which a person's personal life and affairs are free from government and private intrusion and not diminished by a person's interaction with the internet, communication, or other electronic data service, and that requires a warrant prior to government access of a person's electronic data and electric communications. The right to privacy is extremely important to liberty and the survival of a just society. Our forefathers saw the importance of privacy and ingrained it in the Bill of Rights. The Fourth Amendment says, "The right of the people to secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized." They knew that privacy was not only fundamental to justice, but was also essential in the security of the people to live without fear of persecution. So if the Fourth Amendment protects our privacy, why is it necessary to amend the state constitution to add a right to privacy? Well, the world as we know it has drastically changed from days past. Our communication and private record keeping have gone from pen and paper to digital. This doesn't make the information any less private. We hold so much private information these days in the palm of our hand. No one should have access to it without our permission or due process. I urge you to vote ought to pass on LD 1529. Thank you for your consideration, and I will answer any questions.
Thank you so much, Representative Fockingham. Committee members, are there any questions for Representative Fockingham? I am not seeing any questions for you. Again, we appreciate your testimony today.
Thank you. I'll see you in a few minutes, hopefully.
Yes, we'll be in touch very soon. Ms. Melnick, you are here to testify in support of 1529, and you can proceed when you're ready.
Thank you so much. Thanks for hearing me today. I am pinch hitting this afternoon, for Michael Cabetta, who had a conflict today. So I'm testifying on behalf of the ACLU of Maine in support of LD 1529. Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. My name is Alicia Melnick, and I'm here on behalf of the ACLU, a statewide organization committed to advancing and preserving civil liberties guaranteed by the Maine and U.S. constitutions. On behalf of our members, we urge you to support LD 1529. In a seminal United States Supreme Court case, Justice Brandeis wrote, "The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognize the significance of our spiritual nature, of its feelings, and of our intellect. They knew that only a part of the pain, pleasure, and satisfactions of life are to be found in material things. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred, as against the government, the right to be let alone, the most comprehensive of rights and the right most valued by civilized men. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment." Although Justice Brandeis did not live to see our information age, his words are perhaps more relevant today than they even were in his time. From using the telephone to seeking medical treatment to applying for a job or sending email over the internet, our right to information privacy is in peril. Our personal and business information is being digitized through an ever-expanding number of computer networks and formats that allow data to be linked, transferred, shared, and sold, usually without our knowledge or our consent. The same technological advances that have brought enormous benefits to humankind also make us more vulnerable than ever before to unwanted snooping. Enjoying the right to privacy means having control over your own personal data and the ability to grant or deny access to others. The Maine Constitution's prohibition against unreasonable searches and seizures and its protection for natural, inherent, and unalienable rights already provides the protections sought in this resolution. The resolution would provide overlapping protections and, importantly, extend privacy rights against intrusion by private companies whose practices can cause serious privacy violations. The Privacy Act of 1974 applies only to government agencies and is filled with loopholes, and the private sector is virtually unregulated. That is why this resolution would be beneficial to shore up the information privacy rights of this and future generations. We urge you to vote ought to pass. Thanks so much for your time and for your long day already today.
Thank you very much, Ms. Melnick. Committee members, are there questions? I see actually Representative Babbage has a question for you. Go ahead.
Thank you, Madam Chair. I appreciate it. Hello, Ms. Melnick, and thank you for being here. My only regret, I think, about these two bills being brought before us is that I wasn't asked to be a co-sponsor. But having said that, this is immense, and we need to proceed very cautiously as to being precise with what we intend. My question for you is to ask, the Warren Court's legacy was case by case applying the Bill of Rights to the states through incorporation. That having taken place with Griswold and others, what does putting this in the Maine Constitution actually change?
It's a really good question. I have to admit that I feel a bit underprepared to answer that with any precision and clarity. But I'm happy to take that back to the folks at the ACLU of Maine and come back for the work session with a better answer for you. You know, I think some of it is again around explicitness and around clarity for Maine residents. But I'm happy to take that back to the folks at ACLU of Maine.
Appreciate that. Thank you, Madam Chair.
Thank you, and thanks for looking into that further for us, Ms. Melnick.
Sure.
Committee members, any additional questions? I am not seeing any. I'm going to send you back through cyberspace to the attendance part of the meeting. Appreciate you being here. And as I look at the attendee space, I don't see anybody else who wishes to testify in support of 1529. Oh, I do. Another person, Senator Maxman. Bring her over to the panel. And while we're completing the proponents, I would ask anyone in the attendee space who's an opponent who wants to speak against 1529 to raise their hand and just keep it raised until I'm able to call on you. And Senator Maxman, thank you very much for joining us today. You can proceed when you're ready.
Madam Chair, has Co-Chair Hartnett left? Should I be doing the timing?
I'm timing. I've got it.
Oh, your time. Oh,
yep.
Okay. Thanks.
Thanks for checking. Welcome, Senator.
Hi there, Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Chloe Maxman. I represent Senate District 13, which is all of Lincoln County except for Dresden, plus Washington and Windsor. Thank you for the opportunity to speak in support of LD 1529. The Constitution is a sacred document meant to guide the rights, principles, and protocols of our precious democracy. While I don't believe in radically altering the foundational text, I do see the need for our Constitution to reflect the realities and urgencies of our evolving modern society. One of the principal ways that this is needed in this digital age is to create a right to privacy, protecting all Maine citizens from unwanted intrusion and oversight. As it stands right now, a right to privacy isn't explicitly stated in the federal or state constitutions. Constitutional privacy protections are inferred and pieced together. The strongest way to protect ourselves is through clarifying language. Some may argue today that we must focus on creating statutory laws to protect us against the growing threats of surveillance and privacy intrusion. That's true. Statutory protections currently play a role in protecting personal privacy, and there's no doubt that we need to continue to develop systemic protections. But laws are unable to keep up with the day-to-day changes of privacy policies, cookies, cell phone apps, and all the other rapidly evolving technologies. Laws are always playing catch up with technology. This is especially true as data mining and exploitation has been built into our economy. A constitutional amendment will create an essential backstop as our regulatory system adapts to our constantly evolving world. I thank the committee for its consideration, and I'm happy to answer any questions.
Thank you very much, Senator Maxman. Committee members, are there any questions for Senator Maxman? Go ahead, Senator Sanborn.
Thanks, Senator Maxman. Can you think of another example where we would allow someone to bring a constitutional claim as one individual against a business? And maybe there is one. I can't think of another area of our constitutional law where you'd be able to sue a business under our Constitution.
Well, the Constitution is built to hold our government accountable, and I see that as one of the primary mechanisms of a constitutional amendment. I think that we frequently see that with our right to free speech or right to bear arms, that people feel like those rights are infringed on multiple levels. I can't think of a specific example, but I think it's really important that we have mechanisms as citizens to stand up for our rights.
Thank you both. Committee members, any additional questions for Senator Maxman? I'm not seeing any. Thanks so much for providing testimony this afternoon. And it looks like there's another person who wishes to speak on this legislation, and that is Representative Fecteau. And I don't know if I'm assuming he is for rather than in opposition, but we'll bring him over and ask him. Thank you so much for rejoining us. And I didn't know if your hand was a late supporter or okay, I figured you were. Okay, go ahead, Representative.
It would be a wacky Friday if I came out swinging against this.
I know.
I really just wanted to chime in in support of this, but more specifically to answer Senator Sanborn's question that she just posed to Senator Maxman. And I believe that the U.S. Constitution's 13th Amendment abolishing slavery would allow is a position and the amendment in the Constitution that would allow us to basically sue a private business for an unconstitutional activity. And so if a small business owner or a farmer was using slavery as labor, that would allow us to sue a private business for a constitutional breach.
Thank you, Representative Fecteau. Appreciate you jumping in and providing that testimony. Committee members, are there any questions for Representative Fecteau? Not seeing any. And so thank you very much. And I'm just going to do a final check-in to see if there's anybody else who wishes to speak on 1529. I've called for those who are in support and opposition and neither for nor against. And Mr. Clardy, your hand is raised, but I believe you covered 1529 pretty extensively in your initial testimony. And so I think that at this point, we can bring you into the panel. Mr. Clardy, thank you for returning. And I just wanted to, I note that you spoke extensively on 1529 earlier. And so if you can confine your remarks to any new testimony regarding 1529, we'd appreciate that. Thank you very much.
Thank you, Madam Chair. Actually, I was coming back in to answer, I think it was Representative Babbage's question about what this adds to the state of law regarding privacy. And that's that it actually anchors it in solid text, which means that for justices who are conservative, textual driven in their decisions, there's actually something in writing saying this is a legitimate right and it's to be taken seriously and respected. And that gives it a bit more weight in court. And the other item I wanted to mention is constitutional rights aren't normally used as a basis for tort law, but a right to privacy is also not, just because it's recognized as a constitutional right in defense against government intrusion does not mean that we still don't have a right to tell people that's none of your business. And that's all I wanted to add to the conversation, hopefully clarify a little bit. And that's it. Thank you.
Thank you so much, Mr. Clardy, and appreciate you returning and testifying on 1529. Any questions, committee members? Not seeing any, and no one else has indicated an interest in testifying on 1529. So with that, we'll close the public hearing on 1529. And at this point, committee members, we have just one more bill that was scheduled for today. It's Representative Fockingham's civil forfeiture bill. This is the second time we've scheduled it for a public hearing, actually. And I would really appreciate if committee members were able to hear from the sponsor and I believe one member of the public who has signed up to testify. Is that if folks are ready to I know we've been going straight through since 9 o'clock this morning, and Senator Sanborn, I believe, has another meeting. Go ahead.
I just wanted to let folks know that I have to leave my office, so my camera will be off and you won't be able to see that I'm watching, but I'll still be listening and watching. But I have to move around and then leave my house, so my camera will be off. Thanks.
Thank you, Senator Sanborn. And so we will close the public hearing on 1529. Thank the sponsor, Representative O'Neill. And now we are going to move on to LD 1521, which is a civil forfeiture bill brought by Representative Fockingham, an act to strengthen protections against civil asset forfeiture. And I'm going to bring the bill sponsor over to the panel. Representative Babbage, are you speaking to your dog? Yes. Representative Fockingham, welcome back to the Judiciary Committee. We are pleased to hear from you on LD 1521, and you can proceed.
Okay. Thanks for having me again. And good afternoon again, Senator Carney, Representative Harnett. Good to see you back here. And members of the Committee on Judiciary. I am Representative Billy Bob Fockingham, and I am here to present LD 1521, an act to strengthen protections against civil asset forfeiture. This bill requires that for property to be forfeited under the criminal forfeiture laws, the owner of the property be convicted of a crime in which the property was involved, and it prohibits a law enforcement agency or other entity from entering into an agreement to transfer or refer the property seized in to a federal agency. This bill also requires that the records of forfeited property be posted by the Department of Public Safety on a publicly accessible website. This bill completely ends civil forfeiture and moves all forfeiture to the criminal forfeiture category. It's a really simple concept. You don't lose your property unless you used it in the commission of a crime or knowingly allowed someone else to use it in the commission of a crime. You shouldn't lose your truck because your brother borrowed it and did a drug deal without your knowledge. Granny shouldn't lose her house because little Johnny was peddling crack out the basement door. The Fifth Amendment says, "No person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of public war or public danger, nor any person be subject for the same offenses to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation." If district attorneys aren't getting a criminal conviction or seeking one pertaining to property taken into their possession, then it needs to be returned. It's that simple. It's time to end this workaround that makes people prove innocence rather than prosecutors prove guilt. This is one of the founding principles of our country. Please vote ought to pass on LD 1521. Thank you for your consideration. I'll answer any questions.
Committee, thank you very much, Representative Fockingham. Committee members, are there any questions for Representative Fockingham? Go ahead, Representative Moriarty.
Thank you, Madam Chair. And good afternoon, Representative Fockingham.
Good afternoon, Representative.
Two questions for you. One has to do with Section 4, which is page 2.
Okay.
Okay, you see the word computers in boldface there?
Yes.
So what precedes that paragraph in the statute that you've cited? Computers appear to be they're number 7A of what must be a list of different things. Do you know what comes before it or even after it?
Firearms?
Yeah.
Is this a rhetorical question or
No,
you know
seriously, I
the-
don't know.
I think Representative Moriarty, we can get that information for you.
That's fine. Yep.
I don't have the answer to that.
That's fine. That's fine. My second question had to do with Section 5, and why is it that seized property cannot be transferred to another agency or state or the federal government?
The reason why that's typically put in there in laws of this nature is so that local agencies don't just do a workaround. Basically, if there's a state law stopping local police from seizing cash or property, that they would just simply use a federal agency to hand off the property to, and then get a return. That's the reason why it was in there. And of all the sections in this that I would, be willing to amend, that's probably one, because my intention is not to impede law enforcement in normal activities. And I've had a pretty good discussion with the state police in where this would sort of impede their ability to conduct normal activity. So that would be a section I'd be willing to look at to changing.
Very quickly, my concern is that local agencies might be burdened with storage responsibilities over a long period of time that they can't handle because they can't dispose of the stuff elsewhere.
Yeah, and there's a few, and I'll admit there's a few other issues with that section too, where it's not meant to basically it's not meant to insinuate that they would be working around the law, when in fact in some cases they might take into their possession evidence of a crime that happened outside of the state where it's out of their jurisdiction, but basically the federal agency could take that into their possession. So they do a local or a state agency would apprehend the suspect with the evidence and really not be within their jurisdiction to do anything about it, but they could hand them off to a federal agency where it would be in their jurisdiction. And that's not the intent of this bill, is to stop normal and good practice law enforcement. It was just the intent of the bill to stop that workaround to the seizure part of it.
Okay, thank you.
Thank you both. And Representative Thorne, go ahead with your question.
Thank you. And welcome, Representative Fockingham. I appreciate you coming over to the Judiciary Committee to visit with us.
It's great to be here. I think this is my first stop in the Judiciary Committee this year.
Representative Fockingham is with me on Marine Resources, so that's an imperative. I assume at some point that this has to do with long-term seizure, correct? It doesn't apply to if you're pulled over with somebody else's vehicle doing something illegal, that they can't seize it to do, that they can still seize it to do their evidence, but then they can release it to the rightful owner. Is that correct?
Yeah,
for example.
Yeah. This has nothing to do with holding evidence until it's a trial has been adjudicated. That's that sort of thing. If it's evidence in a court case that hasn't been adjudicated, then yeah, by all means, that's not to be included on this. You're not just going to hand something right back to a person,
right?
Without going through that process. But basically, at the end of that process, this is to stop the act of possessions being taken civilly that aren't connected to a criminal conviction.
Okay. Thank you.
Representative Evangelos?
Thank you. Just a quick question. Thanks for that. Representative Falkingham, did I hear you straight that if a criminal defendant who's had their items seized is cleared and found innocent or charges are dropped, that they have a difficult time getting their property back?
It's been the case in some instances. As far as the state of Maine goes, we do a pretty good job. I've worked with a group called the Institute for Justice, which works on cases, issues like this nationwide, and they rank Maine as a B plus. So Maine does a pretty good job with their criminal forfeiture laws, and that's why this bill is actually fairly small. There's not a lot to be cleaned up. But in some cases, yeah, people have had to basically prove possession, prove innocence to get their property back. And I think that's a little bit antithetical to the way that it's supposed to be. Basically, all I'm saying is that if law enforcement wants to claim property or retain property that they've seized, that I just maintain that it needs to be tied to a criminal conviction.
Thank you.
Thank you, Representative Evangelos. Representative Babbage?
Thank you, Madam Chair. I welcome Representative Falkingham to our committee. I just wanted to ask you quickly, do you have information regarding other states in the union as far as ending civil forfeiture?
I don't on me, but I could make that information available. I know there's a lot of information out there readily available on the subject.
Thanks. Thank you, ma'am.
Committee members, any additional questions for Representative Falkingham? I'm not seeing any. Representative Falkingham, thank you very much for presenting your bill this afternoon.
Thank you. I just might add, and I don't know if they're going to be here to testify, but there was I spoke to the state police, and one issue that we did touch on was that issue that Representative Moriarty brought up, and also they seemed amenable to the reporting part of it as well. So I hope they're here to testify on that, but I just wanted to bring that up as well.
Thank you for mentioning that. Major Scott is here, and I would just invite you to stay on the panel if you would like during the remainder of the testimony.
Yep, great. Thank you.
Okay, and so that concludes the sponsors' testimony on LD 1521. Looking at those in the attendee space and asking anyone who wishes to provide testimony in support of 1521 to please raise your electronic hand and keep it up till you've had a chance to speak. And I'm not seeing any raised hands. And so at this point, I would ask anybody who has signed up to testify in opposition, please raise your hand and leave it raised. And I see that Major Scott is here, and so I'm bringing him over to the panel. Welcome, Major Scott, to the Judiciary Committee, and you can proceed when you're ready.
Thank you very much, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Major Brian Scott, and I'm here today representing the Department of Public Safety and the Maine State Police in opposition to LD 1521. We take no position on the majority of this bill, which includes sections 1, 2, 3, and 4. However, Section 5 is problematic from our perspective, as this section would prohibit law enforcement agencies from transferring any seized currency under the amount of $100,000 to a federal agency. The state police has the primary jurisdiction over the entire interstate system in Maine, which is the main corridor where deadly drugs are transported in our state daily. As you know, On average, more than one person is tragically killed in Maine every day due to a drug overdose from this poison that is permeating through every one of our communities. These drugs are destroying people's lives while the illicit drug traffickers are getting rich. In 2016, the Maine State Police initiated a drug diversion program where troopers are directed to focus their enforcement efforts on the drug trafficker and not on those who use the illicit drugs. This resulting in our doubling down on our efforts to slow the stream of these toxins from entering our state. We reinstituted our proactive criminal enforcement team and provided updated training in the detection and apprehension of drug traffickers. Troopers on patrol are busy conducting drug interdiction work in an attempt to keep these drugs from reaching Mainers and trying to do their part in holding those accountable who push these fatal drugs on their users. Some of this work includes partnering with other law enforcement agencies in Maine and federal agencies when appropriate. If we end up arresting a drug trafficker and through the course of our investigation, we determine that the drugs came out of, say, Lawrence, Massachusetts, as an example, we will work with our federal partners who have jurisdiction over this type of interstate trafficking case. When this occurs and a determination is made that the United States Attorney General's office is taking on the prosecution of the case, it becomes under their authority. This involves our turning over any currency that we seize to the federal authorities since they are now prosecuting the case. Cooperating with federal authorities allows them to go after the drug traffickers that are higher up in their illegal organizations. The goal is to cut the head off the snake, so to speak. We want to stem the flow of illegal drugs from the kingpins in the drug world. Section 5 of this bill would force us to stop this practice and no longer go after out-of-state drug traffickers who are accumulating their wealth and building their empires at the cost of Mainers' health. For this reason, I urge the committee to vote ought not to pass on this bill. And on behalf of the Department of Public Safety and the Maine State Police, I thank you all for your time, and I'd be happy to try and answer any questions. I will say that I did speak with Representative Falkingham. I heard his comment. We have no problem with transparency and reporting and making that publicly available and posting that on the state police official website. Thank you.
Thank you so much, Major Scott. And I see that we have at least one question for you. Oops. You came in under the 3 minutes. Representative Thorne, go ahead with your question.
Thank you, Madam Chair. Welcome back, Major Scott. Appreciate you being here.
Thank you, sir.
If I were to say, if Representative Falkingham strikes Section 5, would you be amenable to the bill at that point?
Thank you, Representative Thorne. If Section 5 were not included in the bill, what I would say is you wouldn't have heard from me today, and we didn't take a position on the rest of the bill. We thought it was a public policy matter and up to your committee to decide, and we were okay with whatever happened with the rest of the bill. Thank you for the question, sir.
Thank you, Major.
You're very welcome.
Thank you both for that clarification. Committee members, are there any additional questions for Major Scott? I am not seeing any. Thank you once again for testifying today.
You're welcome. Thank you. I hope you all have a great weekend.
Take care. And then finally, I'm going to turn to those in the attendee space and ask if there's anybody here who wishes to speak neither for nor against on LD 1521. And I am not seeing anyone. And so with that, we'll bring the public hearing on LD 1521 to a close. And committee members, is there any, well, thank you, first of all. A warm thank you to Representative Falkingham. Appreciate you being here today. And with that,
I've had a great day watching your committee work.
Thank you. Committee members, is there any final business before we entertain a motion to adjourn? Not seeing any. Is there a motion to adjourn? By Representative Evangelos, seconded by Representative Thorne. And with that, we conclude our work, and a warm thanks to our analysts and our committee clerk for all their great support today. Take care, everyone.
Bye-bye.
Everyone have a good weekend.
Enjoy the weekend, folks.
Take care.
Hummingbirds are back in Carmel.